Good morning, good morning, good morning, amazing law nerd. How are you? Probably hot. It's a warm one today. It's Tuesday, July 28th. I cannot believe it. I can't believe how fast the summer is gone. I can't believe how fast the summer is going. I can't believe all of it. But today we are here for something else I can't believe. Today we are flying to Idaho. I'm surprised. I think some of y'all are surprised. Should we be surprised? Maybe not. But Bryan Kohberger wants to go back to court, and he's going to try to withdraw that guilty plea. So today we are going to take a look at what he filed pro per, what the law says, what the court docket says, and then we're going to go back and watch what the plea says. So we're going to go into court and take a look at that plea hearing, not the sentencing hearing, the plea hearing. And we're going to go take a look. But Bryan Kohberger would like a takesy v. backsies, everybody. Does that mean it's going to happen? No. No, it doesn't. Are we going to talk about it? Yes. Yes, we are. Are all of the headlines that are like Bryan Kohberger withdraws his plea incorrect? Yes. Yes, they are. Asking to withdraw your plea and the court granting that are two very, very, very different things. And the process for that to happen means we've got to go to court. Law nerds, you have lots of questions. I'm going to hold them. We're going to get to questions. Don't worry. We're going to get to questions. But we're going to go through what he is saying. So we're going to go through, I apparently have a bug bite that I have just discovered. That's delightful at the beginning of stream. Emily, you were gardening without gloves. Bleh. It was fine. It was fine. So for all of you who saw this headline or the headlines or the inaccurate headlines yesterday and went, WTF, don't worry, I got you. Don't worry, I got you. We were supposed to go to Massachusetts today. It'll be fine. This seems to have grabbed everyone's attention yesterday. And you know what surprised me the most? Like, trying it to withdraw your plea isn't the thing that's the most shocking to me. What surprised me the most is that he gave an interview to the New York Times. Like, before this dropped. So it looks to me that he seeded this story with the New York Times over the weekend before this was docketed. I'm sorry. What? You want to do an interview. So the reason this story broke is because he went to the New York Times. I mean, maybe they came to him, but it's because he had a conversation with the New York Times over the weekend. And then the New York Times was like, hey, Bryan Kohberger said these things. We're going to go through that statement. Bryan Kohberger said these things. And he made this motion. It didn't hit the Idaho docket till yesterday. The New York Times had it first. He's allowed to give the media his filing if he wants to. He's representing himself. He can do that. And the journalist who wrote the article posted that on social. And then others went to court in Idaho and got the documents because they're still not on like the public docket yet. But this has now spawned a new case, and I'm going to show you that docket as well. So we're going to look at the interview, the statements, the docket, the documents, and then we're going to go back and look at the plea. We're going to talk about the law. Because Bryan Kohberger, I mean, sir, do you have access to YouTube? Takesies v. backsies is a joke. It was a joke. It was, Takesies v. backsies was always a joke. I know. The defense in the Richens case didn't get it either. But it's actually a joke. It's not legal doctrine. It's not real. Jolene 7X in the chat said, how does this work with all the documents being unsealed? We're going to talk about it. I have thoughts, but I want to get through all of this first. And we're going to talk about it. But oh boy, do I have a lot of thoughts. Emily, we don't always get into speculation. I've got some today, and we're going to get into some of the speculation today. I saw Octo in the chat. Hello, Warren. Also, it's good to see you. We also have, it looks like you should be able to see your, nope, I can see them, but you can't see them yet. All right. Well, we're almost there with the member icons showing up when I pull up your chats on screen. It's supposed to be working. It's not working yet. I see them on the back end though, but I don't see them on the front end. It's about soon. It's going to be working soon. It's going to be working soon. Just waiting for Ronald Takesies suing Brett Baxies in civil court. Exactly. We're going to get full Takesies v. Baxies. All right. We're going to roll the intro. I know it's too hot everywhere to deal with this. Again, the way that this all came out with him going, or him connecting with the New York Times, or them coming directly to him, or him going directly to them. I mean, he has to choose to speak to them. This all coming forward because he did an interview with the New York Times over the weekend kind of tells us what we need to know, right? It wasn't just filed on the docket and then people paying attention to the docket saw it. This was strategized for a headline, at least in some part. I can't say it's all strategized for a headline, but it is strategized for a headline in some part. And we're going to talk about the fact that he waived appellate rights. But remember, well, let's roll the intro. Let's roll the intro and we'll get there. Let me know where you're coming in from, what you're drinking, how you're doing. I've got coffee. Is it going to be enough today? Probably not. But we'll do a little road so far, and then we'll get into the documents. Then we'll take a look at the docket, and maybe we'll do the interview first. We'll figure it out together. And we're going to go to the sentencing, not the sentencing. We're going to go to the judge doing the plea hearing towards the end. Unless y'all want to do it first. I think we want to do the new stuff first. That's how I feel about it. You let me know in the chat. Let's go. That's not in the right spot. Why? I was watching weather yesterday, and so I just didn't change it. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I know. Today is a warm one for us. It's probably a warm one for you. The Cavaliers are like now 5 shows that have been weather canceled into their season. So yesterday I was like, Travis, good luck on your show. And then like 30 minutes later, I was like, just kidding. Enjoy going to Buc-ee's. So they had an extra Buc-ee's stop yesterday, and hopefully got some more sleep because the show day that wasn't a show day. But hopefully as they get into Allentown, weather will stay behaving. Weather will stay behaving. I need the weather to just behave. I want to see my kid again. That's all right. By the time we get to Indy, it's indoors. So it's all going to be fine. It's just all going to be fine. It's going to be fine. It's going to be fine. DJ in the chat said, is this the same interview in which his sister also spoke to the New York Times? It's an interview from the weekend that was published yesterday. I've not gone through all of it. I've gone through Koberger's statement. We're going to go through it together. So let's do a quick road so far. We're back talking about Idaho versus Bryan Kohberger. I remember viscerally when news started to trickle out that Bryan Kohberger was going to take a plea. And when we started hearing about that, it was as they were gearing up for trial. It was not on the eve of trial, but it was pretty close to them being ready for trial. And the defense had lost some, I thought, fairly significant motions. We talked about the fact that the defense had lost some fairly significant motions. Everything that the defense had done leading up to that plea had been to try to close different doors as this was going to trial. And those doors were not successfully closed. So when this plea came about, we learned after the fact that it was the defense that approached the prosecution, asked for the plea and if they would be allowed to do the plea, and the prosecution said, yes, you're going to have to do some of a factual basis. You're going to, not a full, but some of a factual basis. You're going to waive your appellate rights. And at that time, I talked about the fact that waiving appellate rights and having this case be final versus it being a death penalty case and having decades on decades on decades of appeal was one of the things that would hopefully give the families some peace. Well, then we get to yesterday, which was what? July 27th. We get to yesterday, and Bryan Kohberger has filed a motion representing himself. And in filing that motion, he was like, hey, everybody, I actually am going to withdraw my plea. Remember, he doesn't get to just do that because he says so. There's court process. And we've seen that before in another case. We'll talk about that in a few minutes. So from the Bryan Kohberger is going to take a plea, which was kind of a quick roundabout of events because Ann Taylor had been arguing, my client's innocent. We're going to prove that my client's innocent. And then when we got down to it, it was, can we get that death penalty off the table, please? He'll go to prison. And then we saw his plea hearing where he admitted to the things he did to each victim, waived his rights, said that he had adequate representation. And at the time, we had talked about whether or not he would ever argue that his lawyers didn't do enough. And at that time, and I think today I will say again, I don't think have a great argument that Ann Taylor didn't overturn every single stone in this case. This was not a ho-hum defense. This was a full-throated, file every motion, argue everything defense. And we saw that with Ann Taylor and her defense team. It wasn't just Ann Taylor. He had a fleet of lawyers and experts and more. He had so much support. But after the plea and after he went to prison and after we started to see the evidence getting unsealed and the rest of it, then the last thing that we covered together about Koberger, to the best of my memory, was an expert coming out and starting to talk about the case and Ann Taylor ripping into that expert saying, there's attorney-client privilege here. You're not authorized to talk about the case. STFU. Like, what are you doing? And it seems that that expert has continued to go around and talk about the case. And I'm just wondering if that has, in part, undergirded this motion coming from Bryan Kohberger, is that there is one person going on podcasts saying, well, this and this and this and this and this. I don't know. So we're going to take a look at it. But the expert stuff was wild because Ann Taylor came out and was like, no, don't do that. You have no authority to do that. What are you doing? And it was absolutely wild. So we've got an interview with the New York Times. We've got a statement from Koberger with the New York Times. We've got his pro per motion for new counsel. And we've got his pro per motion to withdraw his plea or for post-conviction relief. The post-conviction relief being allowing him to withdraw his plea. All right. Are we ready? Are we ready? I think so. I'm ready. You're ready. Let's read the New York Times article and then the statement in its entirety, and then we will get to the motions. I think that's a fair giving us like a full context of the things. Hopefully so. All right. Let's dive into this. I'm pulling up the New York Times article so you don't have to. Emily, is this paywalled? I believe so. I believe so. So for those of you who are just like, is it paywalled? I got you. We're going to read it together. But the journalist who wrote it did post a bunch of this on Twitter. So I don't know. Let's go there first. Law nerds, I didn't think this is what we were going to be doing today. I sure didn't. But Mans wants to talk to the New York Times. He's going to talk to the New York Times. So, man convicted in Idaho college killings seeks to take back guilty plea. Takesies v. Backsies. Gosh, I'm so glad that happened. I'm so glad Takesies v. Backsies happened in court. I don't think I've ever been more happy than Takesies v. Backsies happening in court. Ever. In an interview from prison, Bryan Kohberger said he had filed a petition to reopen the case. We have that petition. We're looking at it together. He blamed his guilty plea on false promises and wrong information. Remember, during his plea, he asked if he had been promised anything. Ann Taylor struck me as a zealous advocate, but she didn't strike me as unethical. He's accusing her of being unethical. Continuing on. This is from Mike Baker. Mike Baker began covering the Idaho murders, it says in his byline, on the day they happened. He is writing a book about the case. So just a note. The criminology student convicted last year. I mean, he pled guilty. So yes, he was convicted, but yes. The criminology student convicted last year of murdering 4 University of Idaho students in their home is seeking to abandon his guilty plea and obtain a trial, claiming he is innocent and was misled into confessing to the high-profile killings. Now, we have seen a lot of things about this case, but Bryan Kohberger being unintelligent, unaware, or someone susceptible to manipulation is not something that has come across everything that I have seen in this case. I said susceptible to manipulation, chat. So, he goes on to say, quote, "My actual innocence is my truth. And the plea hinged on by false promises and blatant disinformation must be withdrawn, must in all caps." Look, the word salad of my truth and disinformation and this sentence is giving, I'm trying to elevate my speech and elevate the way my speech is perceived. This seems to me to be a sentence based on perception, not based on I'm innocent. So that's my take on it. But that's what he said in a statement provided to the Times on Sunday night. Interesting that all this was file stamped on Monday. Isn't it? Isn't it? Isn't it interesting? We're going to read the entire statement. He reiterated in a phone call from prison in Idaho that he had, quote, he had an absolute claim of innocence. It goes on to say Mr. Koberger has not granted an interview or made public comments before speaking with the Times. Yes, it's your first. Yes. It's your first contact. We know. He declined to discuss any evidence or other specific details related to his innocence claim. Well, that seems guarded and calculated because he doesn't want to discuss the details. Why would one not want to discuss the details? He declined to discuss any evidence or other specific details related to his innocence claim, as well as the specific concerns he had about the plea process. Why? What are your specific concerns? The plea has to be withdrawn. Okay, and what are the circumstances surrounding that? Because you know who can waive attorney-client privilege? Bryan Kohberger. Do you know who I think is very, very aware of that? Bryan Kohberger. If he talks too much about the specific plea process, he could waive his attorney-client privilege. And he's smart enough to not do that. So he is also being mindful to not waive attorney-client privilege, I think. So he would not speak about the specific details of his innocence claim or his specific concerns about the plea process. They say it's rare for defendants to win post-conviction challenges. Exceedingly rare. Exceedingly rare. They say that the family of Kaylee Goncalves, one of the victims, said in a statement that Mr. Koberger was like a, quote, mosquito you just can't seem to swat. We're going to go through their statement. This might be the entirety of their statement, but I have the entirety of the Goncalves family statement. So we'll go through that afterwards. Some of that will be repetitive because it's summarized here. Quote, the real tragedy is, and this is continuing from the Goncalves statement, if even a fraction of the energy spent trying to free a guilty man were directed toward honoring the victims, there would be statues of them on every corner, parks bearing their names, and days set aside to remember the lives they lost at the hands of a narcissist. The Latah County Prosecutor's Office did not return a call seeking comment, but the Idaho Attorney General released a statement saying that his heart went out to the victims' families, noting that they had already endured unimaginable loss and now must face today's deeply painful news. Yeah, I hope the families are able to get to a place where they're just like, whatever with him. Just whatever with him. And I hope they're able to get there. The Attorney General said, my office stands ready to do whatever is necessary to ensure justice is fully carried out. And then they go on to talk about the case. Going back to November 2022, the 4 murders in Moscow, Idaho, a college town that had not seen a homicide in 7 years, captivated the country for weeks as investigators struggled to identify a subject. I don't know if they struggled to identify a subject. I just don't think they told the public the work they were doing, because we've seen all the work that's gone in behind the scenes. I wouldn't say struggled. I would say as the public was unaware of the police work that was ongoing. I'm going to see if they have any more from Koberger's statement versus a rehashing of the case. They go on to say, in court, law enforcement officials outlined the evidence against Koberger. His DNA was found on a K-bar knife sheath that had been left next to 2 of the victims. Amazon records showed he had purchased a K-bar knife and sheath months prior. He also purchased a sheath again, to the best of my memory. He drove a white Elantra, the type of car that investigators determined had been on surveillance video. Koberger's phone showed he was out that night with his phone turned off at the time of the murders. Koberger declined to discuss the evidence against him in his call with the Times. He said, quote, the intention is for all of those questions to be investigated and answered appropriately in a trial setting. You had the opportunity to have this all vetted in a trial setting. You had the opportunity. All of this in a trial setting. And now you waived your right to a trial. And now you want a do-over. Full takesy v. backsy. Goes on to say, Koberger, who had court-appointed representation throughout the case, ended with his guilty plea, said he prepared the documentation to challenge the case on his own. We'll see that. It's a handwritten pro per filing. He requested to have a lawyer appointed to him going forward. I mean, we'll talk about how much money the state of Idaho has already spent on Bryan Kohberger, that in his legal representation, not including his incarceration. In a handwritten filing made public by court officials on Monday, Koberger focused on a claim of ineffective legal counsel. He said his lawyers failed to disclose or review exculpatory evidence and had made promises about what life in prison would look like, including details about visits and employment. Those pledges, he said, induced him to agree to the plea. Sir. I have questions about the exculpatory evidence, but also if you're innocent, whatever you're presented with shouldn't really matter because you know the truth. Second, you're telling me you were induced to plea to prison for the rest of your life because they said you could have a job? Okay. Okay. Sir, you can't play smart and stupid at the same time. So, those pledges induced him to agree to the plea because he was promised what prison life would look like. And shockingly, the other prisoners are not nice to him. He has not made friends. Nobody respects him as if he is a serial killer. And Emily, you're speculating. Yep, I am. Prison life isn't what you thought it would be. That's not a reason to withdraw your plea. Also, your attorney's telling you that prison would be different is not going to work. So these pledges, he said, had induced him to agree to the plea. But Your Honor, a delightful prison life was pledged to him. Well, sorry, Koberger, it was not donated. Apparently, it was just pledged. Why does it always come down to pledged versus donated? Red Hot Mama Kate said, wasn't he getting a master's in criminology? No, he was getting a PhD in criminology. He was a PhD student. Continuing on, the pledge of the prison life. We're going to go to the full document about his statement about abandoning his plea in a minute. They say after he was arrested in December 2022, Koberger's initial lawyer said his client was eager to be exonerated. Court-appointed lawyers spent more than 2 years challenging the evidence collected against Koberger, only for a surprise plea deal to come together a few weeks before trial was supposed to start. It was surprising, but last-minute plea deals happen all the time. They happen all the time. I think Jordan in the chat said the pledge v donation callback was elite. I really think that pledged versus donate was our first in what has now become the takesy v backsy lore. Pledge v donate was our first one. Pledge versus donate was the very first. And takesy v backsy reminded us of how delicious it was. So now that lore has expanded with pretty v please and more. Are they going to put in how much? Chat, I know the answer to this. I'm just curious if the article is going to point out how much was spent on his representation. If not, we'll get there. Also, they keep saying court-appointed lawyers. I'm not sure why it needs to be reiterated so many times throughout the article. This is just a curiosity to me. Why does it need to say court-appointed lawyers 16,000 times? They're still lawyers. They're good lawyers. He had more of a legal defense than he could have afforded for himself. They say Koberger accepted responsibility for the murders at a July 2025 plea hearing. He was not required to offer a motive for the killings and never has. I have lots of thoughts about that, but we'll come back to it later. Otherwise, we're never going to get through this today. The lack of a detailed confession outraged some of the victims' family members and even President Trump. Wait, really? Who had called on the judge to demand an explanation from Koberger. Mind your business. This is between the families. I can understand why the families would want a more detailed confession. We'll go through the plea again. I didn't know that had happened, but like, mind your business. And also, it's not on the judge. This is a plea deal between the prosecution. How do we expect people to understand our legal system if the president doesn't understand our legal system? Look, the plea deal is between the prosecutor's office and the defense. The prosecution is part of the executive branch of government. The judge is part of the judicial branch of government. Those are separate. And they have different roles and they do different things. And then the legislature, separate branch of government, also does different things. And they have different roles. And so everyone is supposed to just stay in our lane. The different branches of government, you just stay in your lane. It was set up with like checks and balances and everything. Okay. I also, other than me getting to like take a moment to talk about the branches of government, because there are some, and if you didn't know this, I am not, well, most people don't know this. So I don't even know what I'm trying to say. But here's what I'm trying to say is that most don't know that the prosecutorial branch falls under the executive powers. We talked about it a little bit when the special prosecutor was appointed in the Alec Baldwin Rust case, but we don't always talk about it. And we have a lot of international law nerds who are just like, wait, what? Which is fair. But for those of you that didn't know, that's not on you. When we talk about the branches of government in the US, we don't always talk about where prosecutors fall unless it comes up in a specific case. So prosecutors are under the executive branch, the judges are under the judicial branch, and then, of course, legislative is making the laws. So it is supposed to be that the legislature is making the laws, that the prosecutors are interpreting and kind of carrying out those laws to prosecute people with, again, executive power. And then the judiciary is separate from that. So hopefully that helps. Also, why does this need to be dropped in? Probably because it's just the New York Times. Why do we need to keep calling them court-appointed lawyers? Emily, you're turning into Rick Hogue, but not as smart. I'm really not trying to be overly picky. I am not a stunning writer. I am not. I am a keep it simple kind of a girl, but I'm always curious into the underlying motive, and maybe I get a little too prickly about it, but I really find that there's times where it seems to me that people are trying to slight attorneys by saying court appointed, and I take issue with that quite a lot, because if we didn't have court appointed counsel, like our entire system of criminal justice would just collapse. So people who choose to go into court appointed work are needed. And I just don't understand it seems like they're trying to degrade lawyers by just constantly repeating it, unless the article's about how much a jurisdiction has spent. So it's one of those things that does ruffle my feathers, but I practiced in court for a very long time. I saw a lot of private attorneys come in, and I saw a lot of day in and day out court-appointed attorneys, public defenders, etc. They had more trial experience. They knew the jurisdiction better, and oftentimes they were better lawyers. So I think there are some court-appointed attorneys who rub me the wrong way. I'm not going to say that that's not true, but I think trying to look at them and be like, oh, well, they just become court-appointed because they can't cut it anywhere else is short-sighted and missing the point. Generally, people who go into public defense do it because they feel very strongly about protecting the rights of individuals. It's not a default job. It's not a default job at all, because the amount of shit that sometimes literally, but the amount of shit that court-appointed attorneys have to put up with it's not something you just default to. Not to mention, a lot of you have asked, like, do you think Ann Taylor's mad? This is part of the job. This is part of the job. You can do an amazing job for your client. You can be the best advocate, the smartest attorney. You can do everything in the world, and they will still turn around and shit on you if it's what's best for your case or their case. And that is one of the things that people have to know going into that job. It's not about you. And a lot of people look at, right, it's not about me. If they're going to turn around and shit on me and that's what's best for their case, then it's what it is. Most attorneys don't take and shouldn't take it personally. So, Mother Oates said, Ann Taylor probably has a paper trail. Oh, I'm sure. Look, we can talk about Ann Taylor all day long, but I don't think there's any world where Ann Taylor's not a zealous advocate. Because such a zealous advocate. Jen in Arcadia said she probably expected him to do it. I wouldn't be surprised. I wouldn't be surprised. Because it is the only avenue open here, and we'll talk about that. So, all right. Lona said, will that be made public? Please tell us it's possible. We're going to talk about that. We're just not there yet. Emily, why? You keep talking about the branches of government. The article sent me on a tangent. We've gone full Hogue in the article construction. It's just interesting to me. Like, there's certain things that it's like, why is that necessary? Anyway, they harken back to the plea hearing. We're going to watch it again later. In court, the judge asked Mr. Koberger, are you pleading guilty because you are guilty? Yes, Mr. Koberger responded. He later sat in silence at a sentencing hearing at which family members of the victims expressed their grief and anger. We're not going to go back and watch the sentencing hearing. I was trying to tell someone about the sentencing hearing in this case not that long ago and couldn't even get the words out. No, we're not rewatching the sentencing hearing. Nope. Nope. I have a bedroom upstairs full of boxes. Well, not really boxes, IKEA bags of stuff to send my kiddo off to college in like 3 weeks. Hard stop. Nope. We'll look at the plea though. In the early morning hours of November 13th, we're not going through the crime again. We know the breakdown of the crime. Let's see. One of the experts, one of the experts who worked on Mr. Koberger's defense team has taken particular issue with the plea agreement and evidence. Brent Turvey, a forensic scientist who analyzed the crime scene for the defense, argued that the crime was committed by multiple perpetrators, criticized how investigators documented evidence, and questioned why more testing was not done on a hair found with one of the victims. Note that the defense could have things tested too. Just a note on that. Also, Let me know if we need to go back and look at Ann Taylor's statement about this. We might need to go back where she's like, that's not what we asked him to do. This is so outside his scope. Ann Taylor was literally like, first of all, you're violating attorney-client privilege. He took issue with that and said, no, I'm not. She also said, stay in your lane, that you weren't asked to do a lot of this, just stay in your lane. So it's a difficult parsing between whether this is someone who feels like in their soul that there's an injustice here that they have to speak out about or not. But Ann Taylor was just like, nope, 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 nope. That's not what we're doing. So there's an infight here as well that I'm curious about. But the defense could have done testing as well. They go on to say the lawyers who served as Koberger's defense team have rebuked Mr. Turvey, telling the Idaho Statesman that fucking hell, keep reading, Emily. Telling the Idaho Statesman that he, quote, is now speaking about topics that are still confidential, many of which are outside of his area of expertise. The lawyers did not immediately respond to requests for comment Monday, nor are they going to. They're going to respond in court if it's requested of them. They're not going to say shit. Angela Sanderson Books said Turvey v. Topsy. Yes, and Topsy v. Turvey. 10 out of 10. 10 out of 10, Angela. The lawyers did not immediately respond to requests for comment Monday. Mr. Turvey's concerns were included in a book about the case, quote, Broken Plea. Want to take bets on if Bryan Kohberger's read the book? Look, there's a book. You know what we've seen from people involved in cases that write books? It often doesn't go well. It's giving Courthouse Becky. That might be wrong, but it's giving Courthouse Becky. He might be correct. He might not be. But once you write a book about it, it gives Courthouse Becky. To me. It makes me sus. It's just sus. They go on to say Koberger alluded to those issues in a statement saying that, quote, unanswered questions seem to multiply with each piece of discovery unsealed. What, did somebody give him access to like Reddit? Sir, the internet can operate in like a fantasy realm. Your lawyers can't. This is also where defense attorneys really do get shit on by their clients, is that their job is to tell their clients the truth no matter how uncomfortable that truth is. And that's not what the internet does necessarily. So I'm curious about the amount of information that's coming to him that is informing this decision and how much fan mail he is getting with that information. And unsolicited information. He said that he was okay that a new trial would mean the prospect of a potential death penalty. Sure. Quote, why am I breaking my silence? Koberger said Sunday in an interview from the Idaho Maximum Security Institution just south of Boise. Quote, a lot went wrong in those plea discussions. I really do want that to be heard. When the judge asked if you were happy with your representation, that's the time to say no. You are not an unintelligent individual. You are not under the influence. And it's not the weirdest thing in the world. I've seen it happen in my own cases. I've seen it happen in my colleagues' cases where the court is taking a plea and is like, are you happy with your representation? And the defendant goes, absolutely not. I'm not happy. And then you know what happens? Everyone gets kicked out of the courtroom except the defendant, the defense attorney, and the judge. And then they figure it out. So it happens, I don't want to say all the time, but it happens not infrequently that defendants say, no, I'm not happy with my representation. A lot went wrong in those plea discussions. I really do want that to be heard. The defense went to the prosecution. In a plea agreement that Koberger signed, which we'll pull up if we need to, he acknowledged that he knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in the case. Still, defendants can make other claims about the legal process through post-conviction relief. And then they skip to him being raised in Pennsylvania and moving to Pullman. I'm going to skip through his background. Oh, and that's the end of the article. What they left out at the end of that article is that the only real way in Idaho, when you've raised your appellate right for post-conviction relief to be granted, is if it's a claim of IAC, ineffective assistance of counsel. That's really the only caveat to seeking post-conviction relief if you've waived your appellate rights. So this is the only little noodly asterisk on that. It's, hey, so you waived all your appellate rights, but if you can prove IAC, then you might be heard further about whether you can withdraw your plea. It's not automatic. Okay? Don't worry, I see all your questions. We'll get to questions. I want to just take a minute to remind you that we've seen this before. It's been a minute, but we have seen this before. Remember when Alec Murdaugh tried to do this? In federal court? Right. Alec Murdaugh tried to do this with his federal plea. And the judge looked at him and was like, you waived your appellate rights? Absolutely not. And literally threw the hammer down. Just get out. Just get out. And so in this case, the court may need to evaluate claims of ineffective assistance of counsel, but that doesn't mean that his plea deal will be withdrawn. The standard for ineffective assistance of counsel, to meet that standard, and people talk about this differently, it is a very high bar to prove that your attorney was ineffective in the way that it would allow your plea to be withdrawn. Or alternatively, some people say the lawyer basically had to have done nothing in the case, been asleep at counsel table, and missed requisite and necessary motions. Legal strategy, trial strategy, is not something that's going to rise to the level of IAC. Disagreeing with your lawyer is not going to rise to the level of IAC. It's not going to get there. Brooke Dragon Jen said, question, if this expert is still under NDA, how could he publish anything about this? He says he didn't violate his NDA, and Taylor says that he did. So because he did, and because he wanted to, because he wanted to. And what's the likelihood that Ann Taylor is going to take the time on her own, or that Idaho is going to take the time on their own to sue him? I think he probably rolled the dice. So let's continue now that we've looked at the overview from the New York Times. We're going to read the entirety of Bryan Kohberger's statement together. Just gird your loins on that. I understand that it is frustrating. I think it's more helpful, though. I'm trying to find the link. I think it's more helpful to just go through it, even though you're going to say what you're going to say, because Bryan Kohberger has the right. If he wants to talk to the New York Times, he can talk to the New York Times. Sure. Tangled Charlotte said that the Supreme Court even turned down a case where the defense lawyer fell asleep at trial. Correct. The getting to ineffective assistance of counsel is an incredibly, incredibly difficult thing to do. And he might be trying to go, well, Let's read it and then go back. And keep reading. I know. Keep reading. We're going to keep reading. We're going to keep reading. Keep reading. This is from yesterday, July 27th. This is Koberger's statement. It looked like it was just texted from his prison device, iPad. This is timed at 9:23 p.m. I don't know if that's the sending time or the receipt time in which time zone, but this was sent on July 26th, 2026. Why is that interesting to me? Because Bryan Kohberger filed the documents. They were not docketed until the 27th. They were not like date stamped until the 27th. He signed and dated those on July 22nd. So it seems to me that he was aware that the timing of this would get stamped likely on Monday, and talked to the New York Times over the weekend, which seems incredibly strategic, doesn't it? For someone who's saying that they were bamboozled by their attorneys, this seems like a strategic timing to have this information out with the New York Times. Jolene asked, how much internet access do prisoners get? It depends on prisoner, but some. Yeah, some. It really just depends. But yes, they have devices, so they can. We heard that not Koberger. We heard that Murdaugh got his tablet taken away, but they have tablets that they can use for things. They're not FaceTime calls, but things like FaceTime calls and texting and emailing and things like that. So this is Bryan Kohberger's written statement to the New York Times before he had phone calls with them. Over a year later, it is self-evident that in State v. Koberger, justice was not served. Unanswered questions seem to multiply with each piece of discovery unsealed, and the public demands the truth. At least he didn't say my public demands the truth. I guess that would have been worse. For all of you in the chat just saying, this will not break me. This will not break me. Yeah, hopefully the goat scream just helps ease the frustration. But the self-evident seems to be specific. With each piece of discovery unsealed, the public demands the truth. Unfortunately, the truth shall never be derived from the state's myopic narrative, a work of fiction which has yet to evolve since the PCA, probable cause affidavit, was released nearly 4 years ago, and its faulty premises were never challenged at trial. You could have gone to trial. That ship has sailed. Danita said ChatGPT struck again. I don't think so. I think this is the DSM struck again. This reads to me like Koberger. You know, if you have interacted with folks who want to be perceived, and I am not diagnosing, thank you, chat, for also not diagnosing. It is difficult when your pattern recognition is high. It is difficult. I understand. But I'm sure you have come across folks who want to be perceived as maybe more intellectual than they are. And there is a very forced use of language and a very forced manner of speaking when people are trying to come across and be perceived as quite intelligent, this is trying too hard. All of this is trying too hard. It's like people who are trying to be perceived as wealthy. It's just try hard. And this fits with all the rest of it. It's, transparent is what it is. So there's that. Either way, I don't hate the use of the word myopic. It is a great word. Works well in Scrabble. Unfortunately, the truth shall never be derived from the state's myopic narrative, a work of fiction that is yet to evolve since the PCA was released nearly 4 years ago, and its faulty premises were never challenged at trial. We could have reworked that sentence. But here's the other thing, is that if the state's quote unquote narrative from the probable cause affidavit never changed, doesn't that kind of indicate that by the time they put together the PCA, they knew a bit what they were looking for? Even though they didn't know the who, they kind of knew the what, the where, the when, the why. LK1540 in the chat said this guy could use a verbal smackdown from Count Bloodworth. Bloodworth's writing strikes you as an individual that has to tone it down for the rest of us mere mortals. Koberger is trying to come up to that level and missing. He goes on to say that circumnavigated by a broken plea, the trial never provided the public the clarity conducive to closure, and justice shall remain abjectly miscarried unless that plea is withdrawn. Sir, first of all, your defense team reached out to the prosecution to get a plea. Then you chose to take the plea. Then you did take the plea. And now your sentence structure is just trying too hard. Also, why is the entirety of this so far focused on the public? We have seen people maintain their innocence. You have not once, Emily, keep reading. The public, the public, the public, the public. Sir, we're busy reading Dungeon Crawler Carl. Leave it be. You can probably still get your PhD while you're in prison if you would like to put the letters after your name. Go ahead. We're busy. We have other things to do. For fuck's sake. Continuing on. He says the trial never provided the public. There was no trial. The trial never provided the public the clarity conducive to closure, and justice shall remain abjectly miscarried unless that plea is withdrawn. I hereby declare my intention to enter a not guilty plea and welcome the state the opportunity to prove their case at trial, as well as to, again, file for the death penalty. Sir, you can't just enter a new plea. But you know that. That's just not how any of this works. That's just not how this works. I declare my intention. Y'all, he's pledging to enter a not guilty plea. Sarah Sissy said, wait, didn't the judge have to enter a plea on his behalf because he refused to enter a plea? Yes, the defense chose to stand in silence and allow a plea to be entered for him. He did not enter a not guilty plea. The only plea he has ever entered was guilty. But he now declares that he would bankruptcy. Full Michael Scott. I declare not guilty. I declare. I hereby declare my intention to enter a not guilty plea and welcome the state the opportunity to prove their case at trial, as well as to again file for the death penalty. My actual innocence is my truth, and the plea hinged on by false Sir, your sentence structure is giving you away. And the plea hinged on by false promises and blatant disinformation must, all caps, be withdrawn. Thank you for all who believe in my innocence and continue to critically analyze the case. Your truth and your public, then. I send my love to my family who have never wavered in their belief in who I am, their belief in my innocence. Okay. So that's Koberger's statement sent to the New York Times on July 26, 2026. Let's take a look at his filing in court, because he doesn't in this say that he's innocent. He says that the plea was based on disinformation, blatant disinformation. He says that his truth stands. He thanks those who believe in his innocence. My actual innocence is my truth. Okay. He also had all of the evidence that the defense had accessible to him. We heard motion after motion over it. So, Shoray, my actual innocence is my truth. Yes, it is the fantasy that he has created around himself. So, Phoenix in the chat said, hey guys, I'm on replay crew. Just landed in Nashville for my first ever solo trip to Franklin, Tennessee. Enjoy, go to the Frothy Monkey. That funky monkey. Enjoy Franklin. It's normally not this hot here. I don't know what all this is. It's ew today. So it'll be lovely tonight. Hopefully. It'll be a warm summer night. Shall we go to court? Shall we go look at the filings? A number of you asked, Emily, who filed this? He did. He filed it. Is it time to fly to Idaho and take a look? Shall we? Yeah, we should. Let's fly to Idaho, chat. Chat says yes. Let's go. Just buckle up. There's more. We are going to take a look at both things that Koberger filed. I also wanted to show you the docket in this case, just so you have the docket in this case. And for all of you saying, Emily, what in the world is the TikTok psychic going to do with this? Don't even get me started, because I wouldn't be surprised if she was running for an extension on her appeal to say, see, he says he's innocent. I'm right. This is going to come up in the TikTok psychic's appeal. It's not accurate, but it's going to 100% come up in her filing. She is going to try to pull a Murdaugh saying, but look, there's new evidence. The new evidence is his filing. We knew it's going to happen. We know it's going to happen. If the two of them team up, it can get real weird, but that's going to happen. Let's take a look real quick at the docket in this case. Here, let me see if I can. Emily fights with technology. All right, there we go. Case portal. We're trying. Let me see if we can make this a little bit better. It'll be good. I know. Emily, you need like the Jeopardy music. I know, but it's probably copyrighted. All right. This is the new case of Bryan Kohberger, petitioner versus State of Idaho respondent, because he's filing for post-conviction relief. This is filed in Ada County. This has been assigned and will remain assigned to Judge Hippler. So that is the judicial officer listed here. Idaho's the respondent. I will probably still refer to this as Idaho v. Koberger, but because it's post-conviction relief, the parties are flipped on that. And it'll be interesting to see if the state responds through the Ada County prosecutors or if they respond through the state attorney general or a combination of the two. Petitioner is Bryan Kohberger, pro se, which means at the time he is representing himself. He does not currently have lawyers. Why? Because he waived his right to appeal. He doesn't have appellate counsel. He waived his right to appeal. Events and hearings. July 27th, 2026, new case for post-conviction relief. There's a case information sheet, a petition for post-conviction relief we're going to look at, the affidavit in support for appointment of counsel because there is a motion to appoint counsel. There is a motion for permission to proceed on partial payment of court fees, which we're not going to look at. He's pro per. He's asking for waiver of fees. That will be granted. Of all the things that will be granted, the waiver of fees will be one of those things that'll be like, yeah, it's fine. And then again, another filing, which is a duplicate of the motion for appointment of counsel. We also have the affidavit and petition for post-conviction relief. So we're going to take a look at that. But this is what's on the docket. This is what's been filed. All of this hit the docket officially yesterday. But as we've seen in other cases, the New York Times had it early because it was provided to them by one of the parties involved in the case. In this case, Koberger. So, all right. We need more lip gloss. It's a lighter color than the other one, but I like it. A lot of you are asking whether the state's prosecutors would respond. I don't know how they divide it up in Idaho. I don't know who handles post-conviction relief. It could be either, but the lead prosecutor on the case, I believe, has retired. So it's either way, it's not going to be the lead prosecutor from the case. All right. Let's look at the motion for, appointment of counsel first. And then we will look at the motion for post-conviction relief, because that's going to take the most of me reading this man's handwriting, which for me is not easy. His handwriting makes my dyslexic brain, and I'm not saying that in jest, I am in fact dyslexic, but it makes the way that he writes his letters just is difficult for my brain to read. So we're going to do this one first because it's less of his handwriting. And that's how that decision got made. This was file stamped July 27th, 2026, State of Idaho versus Bryan Kohberger, motion and affidavit in support for appointment of counsel. Comes now, Bryan Kohberger, defendant, makes this motion. Notice this looks like a Mad Lib. The forms do look like Mad Libs forms. For those of you that's a very dated reference, I do think we should bring Mad Libs back. They were my favorite thing to do on road trips with my family. Mad Libs always made me laugh. Here's the problem with me doing Mad Libs is that my grasp always of what is this is where most people would struggle, I think, now with Mad Libs, would be that not everyone has a great grasp of like, what's a noun versus an adverb versus an adjective. But I think if we brought back Mad Libs, that would get better. They were so much fun. I know. For those of you asking what's a Mad Lib, they were fun little stories and you had to pick a word to fill in. And the way that we would play Mad Libs is you would generally have a sheet and it would say like noun, adjective, adverb, and you would just pick a noun, adjective, adverb, and then you would go fill them into the story and read it. And they would be just absolutely silly because you would just fill out a random list of words and then pop them into the story. So they were really fun. They were really fun games to play before you would play like Heads Up when you were either in line for something. A lot of you said, yes, we did it in line at amusement parks and what have you. We used to do them on road trips. They're so much fun. J. Renee Chase in the chat said, I do Mad Libs with my fourth graders. You must be their favorite. You must be their favorite. Thank you for doing Mad Libs with your fourth graders. If they're still around, I need to bring those back. So a lot of you still use Mad Libs. I love it. Oh, they were so fun. So fun. Anyway, so this looks like a Mad Lib to me. He circled defendant. The next one, he didn't circle defendant. Sir, just follow the basic instructions. Defendant is currently incarcerated within the Idaho Department of Corrections under the direct care, custody, and control of the warden. And then that's the warden's name, I believe, though it looks like it says Doug Governor. I don't think that's what it actually says, but that's what my brain has decided it says. I don't think the warden of his prison is actually named Governor. Anyway. But if that is a different word and that's the name of the warden, I didn't go look up the name of the actual warden. It might be something else. But anyway, he's under the custody of the warden of the Idaho Maximum Security Institution. I also think there is a name. I don't think he put the name of his prison. Hold on. We need we're phoning a friend real quick. I really think that we've got a playing smart and stupid, but according to the interwebs, he is still housed at the Idaho Maximum Security Institution. I didn't realize it didn't have a more proper name. So there's that. And I don't know who the warden is. Let's see. We'll see if the internet can tell us quickly. Who's the warden? Because this is all public information. His name is Derek Governor? For real? Oh my fucking God. Governor. Governor? Okay. Sure. All right. That's actually his name. It's not the governor. His name is actually Derek Governor. Okay, that's fantastic. From judge to governor, the governor of the IMSI. Sure. Okay. Fantastic. That's great. I love that. Sure. Warden Governor. Perfect. He goes on to say, the form goes on to say that the issues to be presented in this case may become too complex for the defendant to properly pursue. He didn't continue to circle that he's the defendant. I'm filling it in. Defendant lacks the knowledge and skill needed to represent himself. Defendant requires assistance completing these pleadings as he/she was unable to do it him/herself. He didn't circle any of those. Dated the 22nd of July, 2026, signed by Bryan Kohberger. And then there's a support of appointment of counsel affidavit. I am Bryan Kohberger. I am currently residing in the Idaho Maximum Security Institution. He doesn't have the money to pay for counsel. I am forced to proceed. If I am forced to proceed without counsel being appointed, I will be unfairly handicapped in competing with trained and competent counsel of the state. I am untrained in the law. I'm unable to provide any form of security. I am without bank accounts, stocks, bonds, real estate. I don't have access to funds to hire private counsel. But it does end with further affiant saith not, just like South Carolina, which is my favorite way to do this. Oh, and then he circled it here. Wherefore, defendant respectfully prays that this humble court issue its order granting defendant's motion for appointment of counsel to represent his interest, or in the alternative grant any such relief to which it may appear the defendant is entitled. Signed, and dated July 22nd, 2026. And then he has this sent to the Latah County prosecuting attorney, William Thompson, and Ashley Jennings. I believe that Thompson has retired. It will go to Ashley Jennings. I don't know if it will need to go to the state's attorney general, but if it does, they will sort that out. That's not going to be a hindrance to him. Are we ready to take a look at his affidavit? Miguelina, do you want to let's let the app know that we are going to be looking at Koberger's request to withdraw his plea, just to remind the app. Thank you very much. You guys, we have some new stuff coming to the app in the coming weeks. I'm so excited. We have some new stuff for you. I can't wait. So after finals and college move-in, we've got some new stuff we're going to be rolling out in the app. Don't worry, we'll break it the first couple times, but it's going to be great. We're going to test it before we do another trial, and it's going to be so much faster so that we have an easier way to get all of you just right to where you need to be. I'm so excited. All right. Let's take a look at what he has to say. Emily, you're already put out with this. Yeah, waiving your right to appeal means waiving your right to appeal. You know, it has to mean something. So let's take a look at his 8-page petition and affidavit for post-conviction relief. And replay crew, if you zoom right to this point, hi, welcome. Of course you did. I respect that. Let's go. This was file stamped July 27th, 2026. And these things, again, take a little bit of time to get to the prison from where he's sending them. Koberger versus State of Idaho, because this is a post-conviction relief that's being sought. Petition and affidavit for post-conviction relief to Judge Hippler. And we have seen that Judge Hippler is who is docketed for this, or whom is docketed for this. I want to see that hearing. Place of detention, Idaho Maximum Security Institution. Name of location and court which imposed judgment sentence, Ada County, and then the location of the courthouse. Case number, and that's the underlying case number. Offense convicted, 4 counts of capital murder, felony burglary. Date of sentence, July 23rd, 2025. Terms of sentence, life without parole plus 10 years. Check whether a finding of guilt was made after a plea. Of guilt. Did you appeal from the judgment of conviction or the imposition of sentence? No, because he waived appeal. State concisely, again, this is the form he's filling out, state concisely the grounds on which you base your application for post-conviction relief Use additional sheets if necessary. State concisely, but I guess if you need more room. A, ineffective assistance of counsel during criminal proceedings. B, plea not knowingly or voluntarily entered because was induced by unkept promises. C, plea not voluntarily entered because of threats asserted by petitioner's legal counsel. Threats. You want us to believe that Ann Taylor was threatening you? Okay. Sure. Sure. Chatty Cathy in the chat said, "Da nerve." I'm also very curious if Bryan Kohberger's perception of being threatened by Ann Taylor went something like this. Hold on. This is Emily speculating, wondering, or pontificating, because I'm not new at the criminal law situation. Here's the evidence against you. And if we go to trial, it will likely go like this. You have told me that your goals, and this is my speculation, you have told me that your goals are not to be put to death by the state of Idaho by like firing squad, which they just recently brought back. If you would like to do that, then your options are go to trial and I will argue the best I can, but these things will not play well. Ask the prosecution if they will take the death penalty off the table for you pleading guilty, and then you'll spend the rest of your life in custody, and custody will look something like this. Or go through all of this trial and do the rest of this. And we can do that, but this is what it's going to look like. I just wonder if by threats, he means that Ann Taylor sat down and said, this is what this is. I'm just curious. Because I have seen more than a few defendants say my lawyer was threatening me when the situation was their lawyer telling them what the situation is when laid out in a very neutral way. It's interesting sometimes when being confronted with one's own actions that can feel like a threat if someone is not ready to maybe face that. So I'm just very curious if that's how he's perceiving a very candid conversation of this is where we're at in a very dispassionate and maybe not sugar-coated way, in a very just let's have a conversation. And I wonder if that conversation of like, this is what they have, felt threatening to him. Because I can't imagine Ann Taylor threatening her clients. The cold, harsh truth of reality, I could see. The threats, no. However, I guess we'll see. When allegations like this are leveraged against an attorney, though, the court can have a hearing about that is outside of the view of the public. There can be a closed hearing so that it doesn't violate attorney-client privilege. Just asserting that there were threats made, just asserting that there were unkept promises is not going to be enough to violate attorney-client privilege. Also, isn't it interesting when people, especially women, speak in a non-placating way? Sometimes that's just perceived more harshly. Just showing up, doing your job, and being like, this is what it is. Help, you're threatening me. Riley Bear, Emily, did any client try to pull this with you? I was not a defense attorney. I was a prosecutor. But yes, witnesses and victims. The prosecutor was threatening me. Well, what I said was, we've subpoenaed you, and if you don't come to court, then I will send a ride to pick you up, and that ride will be badged. That's just what's going to happen. It's not a threat. We do not want to send a ride. We would prefer it if you come to court on your own. But yes, all the time where people are like, the prosecutor was threatening me. What did the prosecutor do? They said I had to come to court on my subpoena. Okay, sure. Yeah. Emily, did you ever have to follow through with those next steps? Yes. Yep, sure did. In one of my first felony trials. It was not my favorite. But we've told part of that story. Some of you said, are they free rides? They are free rides. It's just not everybody likes being given a free ride in the back of a cop car. Did they get a free ride home? I always tried to make sure that people got a ride home. And sometimes when people came to court voluntarily, I still asked law enforcement to give them a ride home to make sure they got home safely. So yeah, there were times that we did that in a way that was easier than the, hey, you've been subpoenaed, we're going to send somebody to pick you up. But yep, sometimes it happens. A lot of you are saying gas is kind of expensive. There's that too. All right. Are we ready? Let's continue on. I just wonder. I wonder what Bryan Kohberger's perception of being threatened by his attorney is. I don't know if we're ever going to know more about this because that conversation would be sealed. I also wonder what the unkept promises are. Oh, sure, the vegan meals in prison will be great. I don't know what the vegan meals in prison would be. Mashed potatoes not made with butter, perhaps? I don't know. Spaghetti without any sauce, or I guess without any meat sauce. I don't know. Like, what are the unkept promises? Too much beans and rice is what you all are saying? Yeah. What are the unkept promises? And this the court can vet out without violating attorney-client privilege, but Ann Taylor will have to come to that hearing and essentially defend herself. Before this goes any further, this will have to be decided. Is he vegan? He asked for vegan accommodations in custody. So, yes. Prior to this petition, have you filed with respect to this conviction? He says no on each count because he waived his rights. But saying that his attorney threatened him and that his plea was induced by unkept promises is tough. Oh, this is fair. Darla said spaghetti isn't vegan, it's pasta made with egg. Fair enough. I guess I should have known that because I have on rare occasion made fresh pasta and yes, basically just egg. I don't know. Maybe he gets rice noodles. I imagine most of the ramen and commissary, though, is made with some kind of chicken and or beef broth. But I'm sure he's not loving the lack of control of prison life. So we'll see. Is your application based upon a failure of counsel to adequately represent you? State concisely and in detail. Look. Excuse me, who is writing the rules on this petition? State concisely and in detail. Which would you like? State concisely and in detail. This is exactly verbatim what the form says. This is the kind of thing that would make my ADHD brain crash out on a test because I would spend half of the time trying to analyze whether they want me to be concise or they want me to be detailed. Then I would feel like the question is the test. Yeah, this I hate. Either way, state concisely and in detail what counsel failed to do in representing your interest. A, I'm going to do my best. His handwriting is difficult for me. That's why it's up on the screen. Hopefully it's not as difficult for all of you. Let's see if we can make this bigger this way. All right. Failure to disclose of... Are the R's backwards? Or is it my brain? His R's might be backwards. Failure to disclose of or review exculpatory evidence, i.e. unknown hair in Chapin's hand during plea discussions. Shit. We're going to have to review at least a little bit, probably next month, what the investigator is saying, because I'm just wondering if this is coming from the investigator that wrote the book. And like, I'm torn on that because I don't want to give it more oxygen, but I'm also curious if this is where it's coming from. Let's see. Failure to disclose of or review exculpatory evidence during plea discussions. B, counsel's insistence that petitioner's plea need not be truthful, despite petitioner's vehement denial of actual guilt. Ann Taylor doesn't strike me as an individual that's afraid to go to trial. But again, I don't know Ann Taylor from anybody. I've just seen how she defended this case in court. So I'm curious I really am curious as to where this is coming from. Promises, let's see, we're on point C. Promises made by counsel regarding LWOP status, i.e. immediate contact visits, freedom of movement, employee, and elaborate lies of DR life. I don't know what he means by DR, but are you trying to withdraw your plea because you did not have you couldn't get a hug? Also, I think, a lot of you are saying he means death row. Thank you. I did not put them together. My brain is trying to process the handwriting, which I am struggling with. But I'm really curious. However, your conversations or misperception about freedom of movement, employment, and immediate contact visits aren't going to be sufficient to overturn your plea. That's just not going to cut it. Elaborate lies of death row life. Does he think it's going to be better if he was on death row? Is this the beef? Like, this would be better for me if I was on death row? Like, I want the death row prison lodging instead of LWOP? All right. For those of you who asked about LWOP, life without the possibility of parole. So life without parole. Why is it it's LWOP? I don't know why he put LWAP. Wow. We are professionals. It's not an A, it's an O, but it's said LWOP. I guess maybe that's why he put an A in there, but LWOP, life without parole. I don't know why without gets 2 letters in the LWOP abbreviation. I don't think too deeply about it, but he spelled it LWAP. All right. Continuing on. Are you seeking leave to proceed in forma pauperis, which is have court-appointed counsel because you can't afford it? Are you pleading essentially poverty, requesting the proceeding be at county expense? The answer is yes, which said he needs to fill out a motion and affidavit for fee waiver, which he did. Look, I'm in custody. I don't have a bank account. I don't have any money. I can't pay for this. So this isn't the pro per representing yourself. This is the financial waiver that I don't have the money or access to money at all. Are you requesting appointment of counsel? Sorry, that was me moving the document. Are you requesting appointment of counsel to represent you in this case? If your answer is yes, you must fill out a motion for the appointment of counsel, which he did. He answered yes. State specifically the relief you seek, a withdrawal of a guilty plea. Dated July 22nd, 2026. Signed Bryan Kohberger, certification under penalty of perjury. You know what? He signed something else under the penalty of perjury too. We'll go look at what he signed, because I think that would be helpful. We'll go look at his signed plea form before we rewatch the plea. Rocker Cheesemay said, wait, they fired Santa Claus? No, Lawyer Santa Claus retired. Lawyer Santa Claus was supposed to retire before the Koberger case happened and postponed retirement until after the Koberger case. So no, he retired. He retired. He was ready to retire when this case came in. I can't imagine having a career that long. I mean, I imagine the career in his county was a little quieter than LA, but I can't imagine getting to the end of a prosecutorial career that's that long, being ready to retire, and then being like, oh, here's a quadruple homicide. I can't imagine what that would do to your stress and health. Continuing on with this filing, this is the certificate of mailing. This is his affidavit. So for those of you that were like, wait, he wrote more. Yes, this is the affidavit. I didn't want to just go to the affidavit. I wanted to look at the entirety of the filing because I thought that would help. And I like looking at all the documents. So, sworn affidavit of facts. Bryan Kohberger, being first duly sworn an oath, deposes that it is hereby declared. Oh, we're not done with the coffee. All right. It is hereby declared that during attorney-client discussions, most of which included all members of Bryan Kohberger's immediate family. Oh. Well, then we might already have some attorney-client privilege issues. Because if members of his family were there, then those conversations weren't private. That's an interesting quirk. That seems to waive a lot of privilege. Ooh. I would argue, and I wonder if the media will argue when this invariably gets set for hearing, I wonder if the media will argue, or if I will need to be like, hey, it's me, it's media, will argue that because attorney-client privilege has been waived, because Bryan's immediate family was present at the discussions, that should be public. But now you're going to see potentially at a hearing, and again, this hearing may be sealed when it happens, because there will need to be a hearing on what happened with counsel to determine if there was ineffective assistance of counsel. That's the first thing that needs to happen. But you're going to see potentially him testify under oath, because he'll have to. He's the one making these allegations. You're going to see his family potentially testify under oath, because they would have to. They're witnesses. And his attorneys testify under oath about what happened. Chat's asking, but would he have to agree to his family being there? He would have to agree to his family being there, but he has the ability to waive attorney-client privilege, and the presence of his family being there can waive it. So there might actually be a fight over whether or not this can be public. Because generally, when you're fighting over things privately discussed with counsel, that's all ex parte between the defendant, the judge, and the attorneys. But I think there's an argument for the state to make that because members of the family were there, that this is not privileged anymore, that privilege has been waived, so that the state has the right to be there, but also that the public has the right to be there. That's going to be really interesting. Rachel said in the chat, I assume, but would like confirmation, Ann Taylor's absolutely conflicted out of representing Bryan Kohberger in this motion. Ann Taylor, anyone that would work in her firm with her, and any of the other defense attorneys that worked on this case, because there are multiple, and anyone in those attorneys' firms as well. So there would be quite a lot of conflict here. Yeah. Let's see. The question from Empty Profile in the chat said, could that be waived automatically by their presence? Yes. If you are having a conversation with lawyers and there is a third party there, it waives your attorney-client privilege in that conversation because it's now not a privileged conversation. There's a third party there. Interesting. That's an interesting detail. Petitioner, he goes on to say, petitioner was convinced to falsely confess to capital murder and felony burglary by coercion, disinformation, false promises, and the withholding of exculpatory discovery. The following is material to the inception of the plea deal. I think that's what that says. To the inception of the plea deal. To the inception of the plea. 1, and again, I struggle with handwriting a lot, and this is difficult. So this is tough. Let's see. 1, counsel's failure to inform petitioner of exculpatory discovery received during plea discussions, namely clumps of unknown hair found in Ethan Chapin's hands. Again, I'm putting a big asterisk on that because I have some questions about that. That is one of the things that we've seen. Sorry, I'm saving a question from the chat. That's a good question. It's one of the things we have seen discussed by the witness, by the expert witness. Expert was the word that my brain was like, we can't do both. The expert witness that wrote the book. Let's see. So he is saying that exculpatory discovery was received during plea discussions and not disclosed to him. If true, that could cause a problem. Again, I say if true. I am not assuming one way or the other that that's true, but if exculpatory or potentially exculpatory discovery was not disclosed to him, that could cause a problem. However, if he is maintaining, well, I'm innocent, any level of exculpatory evidence shouldn't matter. When you're looking at someone who's like, I didn't do the thing, I don't care what you show me, I didn't do the thing. Like, I wasn't there, I didn't do it. I don't give a shit what you show me. I wasn't there, I didn't do it, unless his argument is his lawyers convinced him that he was going to be wrongfully convicted and he was better not getting the death penalty. But if you're convinced that you're going to be wrongfully convicted, one would think that the strategy might be, well, 1, fight like hell at trial and prove that there's not enough evidence to convict you. And 2, if you are convicted of the death penalty, then you have so many more appeals to you. You have time to then continue to fight, Ali Foley, I'm saving your comment. I think you are correct. So I just have questions. Sassy Southern Girl, that's a great question. I'm going to hold that too. 2, petitioner was convinced that actual guilt was not an important factor in considering plea acceptance. I can't believe that that's true. You said that you were pleading guilty because you were actually guilty. So, Portia Milner in the chat asked, is he claiming coercion? He is. He's claiming ineffective assistance of counsel, coercion, threats, promises. He's going through essentially the statement where the judge says, no one promised you anything, threatened you. He's going through that language and saying all of the things that you say in a plea deal, all of those things happened. We're going to get to his plea. Petitioner was convinced that actual guilt was not an important factor in considering plea acceptance, that death row was imminent, and advised to lie. Petitioner was to, I think that's gain a quote unquote legal victory in entering a false plea. Point 3, a gross misrepresentation of and promises regarding what a life sentence would immediately afford petitioner. Do not pass go. Do not collect $200. Go to prison. I don't know what else you think you're going to get. A gross misrepresentation, he says, of and promises regarding what a life sentence would immediately afford petitioner, and a gross misrepresentation of death row in Idaho, including an elaborate, fabricated story of counsel's horrific experience touring an actual 8x8 death row cell, all communicated to petitioner and his family allegedly by IDOC through counsel, thus constituting threats and promises made to induce a plea agreement. So they told you that death row was awful, and now you regret this like as a housing choice? Because I'm going to read point 3 again. A gross misrepresentation of and promises regarding what a life sentence would immediately afford petitioner. And we saw some of that up above, including visits and employment. A gross misrepresentation of death row in Idaho, including an elaborate fabricated story. It looks like he added in fabricated after the fact to this sentence. An elaborate fabricated story of counsel's horrific experience touring an actual, quote, 8x8 death row cell. I think that Ann Taylor as death row counsel has probably been to Idaho's death row, though, and communicated to petitioner and his family, allegedly, I think that was added after, by IDOC through counsel, thus constituting threats and promises made to induce a plea agreement. So he feels that life on death row versus an LWOP sentence was misrepresented to him. Again, I don't know if that's going to count for ineffective assistance of counsel at all. And it really sounds like he is unhappy with prison life because these okay. That's signed by him, and then the legal mail envelope is included. So, where are we at after looking at Bryan Kohberger's pro per, meaning he filed for himself, request for appointment of counsel, and request for post-conviction relief? The post-conviction relief that Bryan Kohberger is seeking is to have his guilty plea withdrawn and start this case all over again post-indictment. Remember, this was a case that was indicted, not preliminary hearing. We were getting ready to go to preliminary hearing, and then all of a sudden an indictment came down and we all went, wait, I thought there was going to be a prelim. What? So I'm not saying this is going to happen. It would set the case back to there. That's what he's asking to have happen, is to set the case back to after the indictment on a trial track. Now, if that happened, he would have completely different counsel because he's alleged that attorney Ann Taylor was ineffective in the legal sense, withheld exculpatory evidence from him, and threatened him. Now, it does seem like the threat that he is alleging here is what did he say? The counsel's story about the horrific experience of what an 8x8 death row cell looked like. And that was all communicated to Koberger and his family. And that was the threat. Saying that death row isn't somewhere you want to be, that was the threat. And I have to wonder if when Bryan Kohberger and his family were discussing whether he wanted to take a plea deal, whether he wanted to ask the prosecution for a plea deal, that Ann Taylor sat down with him and his family and said, let's talk about the reality of what the rest of your life looks like in scenario A versus scenario B. Those aren't threats. But I guess we'll have to wait and see, because that's what he is making this to sound like. What I thought was very interesting in his filings is that A, he did say that his attorney threatened him. B, he said that promises were made that induced him to make a guilty plea. He also said that he was told that his actual guilt or innocence didn't matter, insinuating that he should just lie to take the plea deal, and that was just fine. So what happens from here? We are next going to go take a look at his signed plea form, plea waiver, and the plea hearing. But in Idaho, he has only one small caveat when he's waived appellate rights. And that one small caveat is whether or not there was ineffective assistance of counsel. And, Your Honor, counsel made prison with life without parole sound better than being on death row isn't going to cut it. But he is alleging that there was, he says, exculpatory evidence that was withheld from him at the plea stage. And I just have to wonder if that is coming from the expert who Ann Taylor had such strong words for after he published a book about this case called Broken Plea, and if that information is coming from there, because I really wonder if that's where it's coming from. So let's see. I'm going to try to pull up that code section real quick. Let's see. I thought I had it turned. I thought I had it pulled up. I think I closed the tab. Me recklessly being like, there's too many tabs open. Let's see. The reading of the handwriting took up so much brain processing that my brain is just mad. My brain is just like, no. So it's difficult. I'm going to try to grab the exact code section in just a minute, but one of the things I am looking for, let's see, post-conviction relief. Let's see. Post-conviction relief. Let's see. This is the wrong type of case. I'm going to keep looking, but at my quick glance from today and yesterday, it does seem that he has a year to file any post-conviction relief. And we did talk about the fact that ineffective assistance is really the only thing that you can tackle when you have waived your appellate rights. But we'll come back to that. I am going to find the actual signed plea. Though we looked at it when it was filed on the docket. I'm just going to pull it up again. I will find the Ann Taylor stuff because I hadn't pulled it up, but I will find the Ann Taylor stuff while we are looking at the plea hearing. Let's see. I just want to find his. Oh, Emily, you can just control F. We can do that. I just wanted to find his signed factual basis. So let's take a look at this first. And then we will take a look at I think we have one more. But let's look at the factual basis first. This is from July 2nd, 2025. Written factual basis. I hereby admit responsibility in count 1. That's the burglary. I hereby admit responsibility in count 2. That's the first-degree murder of Madison Mogen. I hereby admit responsibility to count 3. That's the first-degree murder of Kaylee Goncalves. I hereby admit responsibility to count 4. That is the first-degree murder of Xana Kernodle. I hereby admit responsibility to count 5, the first-degree murder of Ethan Chapin. I plead guilty to counts 1, 2, 3, 4, and 5 of my own volition, dated this first day of July, 2025. Bryan C. Kohberger. So that is the signed. And remember, he's asked about this in court, and we are going to take a look at this in court as well. And we are going to look at all the things the court advised him of in court. And we are going to look at the statements his attorneys made. Let's take a look at the plea agreement document real quick before we go to court. The plea agreement from, let's see, July 2nd, 2025. The state of Idaho, by and through the Latah County Prosecuting Office. The defendant, Bryan C. Kohberger, and defendant's attorney, Ann Taylor, stipulate to the following plea agreement. The defendant will enter guilty pleas to the following counts: burglary, and then the first-degree murders, as stated in the indictment. The defendant will be sentenced to 10 years fixed for count 1, that's the burglary. The defendant will receive fixed consecutive life sentences for counts 2 through 5. The state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in an amount to be determined. The defendant understands A, the nature of the charge to which the defendant agrees to plead guilty and acknowledges that he is not being coerced into entering his plea of guilty. B, the consequences of his pleading guilty, including the maximum penalties that may be imposed and any mandatory minimum penalties. And that C, by pleading guilty, he waives his rights to a jury trial, to confront accusers, and to refrain from incriminating himself. Because once you say that you're guilty, your Fifth Amendment right is kind of gone. You have the right not to incriminate yourself. Pleading guilty is really about as incriminatory as you can get. Defendant further acknowledges that he is satisfied with his legal representation, has reviewed with his attorney all possible defenses, and by his plea of guilty, voluntarily waives those defenses and all claims based upon his constitutional rights. We're at point 6. Defendant understands that if were, again, spell check, just spell check. Defendant understands that if he were to proceed to trial, he would have a right to appeal, including but not limited to A, any issues decided by the court prior to defendant's guilty plea, including any rulings on the admissibility of evidence. B, the judgment, including a finding of guilt and any issues regarding the guilty plea. C, the sentence. Further, defendant understands that if were to proceed to trial, he would have the right to file a motion under Idaho Criminal Rule 35 seeking a reduction of that sentence. Defendant hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case and waive the right to file a motion pursuant to Idaho Criminal Rule 35. Don't worry, we'll pull it up. So he is also waiving his right to file a motion. However, those motions, let's just pull up what that's waiving in the Idaho criminal rules. Hold on, let me get to 35 real quick. Idaho Rule 35. See if we can ensmallin this a little bit. Ensmallin. Opposite of embiggen. Idaho Rule 35, correcting or reducing a sentence. A, the court may correct a sentence that is illegal, from the face of the record at any time. Sentences imposed in an illegal manner or reduction of sentence within 120 days of the entry of... No! The page just disappeared. All right, back to Rule 35. Emily, what have you pulled up? I've pulled up the Idaho.gov criminal rules and tried to make them readable the best I can. Emily Fights with Technology, part 75,000. So just try to make it legible. Sentences imposed in an illegal manner or reduction of sentence within 120 days of the entry of the judgment imposing sentence or order releasing retained jurisdiction, a motion may be filed to correct the sentence. Credit for time served, and then it accounts for that. So when they're talking about you cannot file a Rule 35 motion, the Rule 35 motion just covers the sentencing. So that's what is in that plea deal. Okay? All right. Let's get back to the rest of that plea deal real quick as we finish it before we go watch it back in court. It's the wrong one. Where did it go? There it is. So that's what the Rule 35 filing is, to change the sentence. This is the entire agreement and understanding between the parties, so stipulated this 30th day of June 2025, signed by Ann Taylor, Koberger, and then both prosecuting attorneys. So that's the plea and the waivers that are written. They also took plea and waivers in court. And we are going to go look at the plea and waivers in court. But one of the interesting things that connected as we were looking at this is I think the timing on this is a year, and I'm going to double check, but I think the timing on this is a year. And he filed this, one day before that timing lapsed? Because these motions are all filed from July 22nd. And he was sentenced July 23rd. So this is also a waiting till the very, 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 very last moment. And I don't know if there will be a fight, and I don't think that there will be on this, over the date filed and the date signed. Because this was not filed until July 27th, 2026. He signed it, and I wonder if he mailed it, on July 22nd. So 1 day shy of the 1 year mark. And again, a 1 year mark, not a 365 day mark, a 1 year mark from the date of the sentencing. I'll take a look and see if I don't know if I grabbed the one with the envelope on it. It says legal mail, but it doesn't have a date stamp on it. So I don't know if there will be a fight over the timing, that this will be too late, whether or not this will be untimely. But I imagine if there's going to be an opposition to this, that will come up in the opposition, because it's very, 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 very close. But for those of you asking about what about Shirilla, the statute here says a year, which is just from day and date, not the 365 days we talked about in Ohio. That's a whole different thing. So he should have had a year from the date of final sentencing, though I don't know what date the court actually entered the judgment. There could be, I don't know if there was a delay from the sentencing hearing to when the court entered the final judgment. If there was any delay in the court entering that final judgment, it would be from the day that the final judgment was entered. But the sentencing date was the 23rd. I think there's an argument that that would be the date that holds. But if the court didn't enter it till later, I think there could be an argument that the court's official entry of judgment was later. But I think to be safe on that, you go from the date in court. And so I think you go from the date in court. But we'll see. So this is 1 day short of the sentencing date that it was filed, which I guess keeps it safe so you're not arguing, well, the final entry of judgment wasn't signed by the judge, even though he said at the sentencing date that that was the entry of sentencing, etc. So either way, if it's an issue, we'll see it argued. I don't think this is going to get yeeted based on timing. But it's interesting to have that conversation. I think there are other things that will yeet this. Let's go take a look at the sentencing hearing, and then you guys have a ton of questions. I know that you do. We will go to those questions after we take a look at what was said in, not the sentencing hearing, in the plea hearing. Remember, the plea hearing happened first. Sentencing happened after. Let me see. So the proper date for timing of appeal is going to be final entry of judgment. Again, if the court signed that final entry of judgment after the fact, it would be that date, though I think the day of the sentencing is a good touch point. It's not going to be from the day that the plea was entered. All right. Are we ready to go to court? Let's go to court. Allie B in the chat said, how long do you think it will take to make a decision? This is not going to be quick. This is not going to be quick because there's going to be phases to this, and we'll talk about that after we go look at the plea hearing. All right. Let's see. Oh, what date was this from? Was this July 2nd? Hold on. Let me just take a look. It's on the video. July 23rd, 2025. What day was the sentencing then? Because the plea and the sentencing were separate dates. I don't know if I have the wrong one. Let me take a look because I don't want to go through the sentencing. I think this is the plea hearing, but I do not quite remember. So let's take a look. We're going to court. Law nerds, you ready? We're going to court. We're going to court. Oh, this is the sentencing. Yeah, I don't want to do the sentencing. I need to find the plea hearing. So give me 1 second. That's on me. Let me go grab it real quick. I meant plea in my brain. I grabbed sentencing, not in my brain. Let's see. Sorry, chat. Though we've been through the sentencing hearing, I definitely don't need to go through the sentencing hearing again. It's just going to take me a minute to find the plea hearing again. So let me look for it. I know I've got it. I just don't know where I put it. So sorry, chat, for the pause. Those were, I don't know if you heard those. Those were very, very heavy footsteps of my kiddo. Miguelina, do you mind grabbing that? Because I don't see it quickly, and I have to switch accounts to go grab that. Thank you. If you'll just put that in our document, I appreciate it. I don't know what my kiddo is running around about. Because that plea hearing is what I'm looking for. Thanks, chat. Sorry for the delay. I thought I had grabbed what I was thinking of and I had not. I know all of you are just like 6-7. I know we're not doing Emilyception. I want to go just to the plea hearing, which is what I'm looking for. Not my video of the plea hearing, but like our video of the plea hearing. If that makes sense. There it is from July 2nd. I grabbed it, Miguelina. Thank you. All right, perfect. That's what I was looking for. Give me 1 sec to get this pulled up. This is from July 2nd. And that was on me. I put in the wrong hearing that I was looking for when I was doing this yesterday. My finger said sentencing. My brain meant plea. Let me make sure I've got our closed captioning on, and we are going to go take a look at the whole thing together. Yes, I did cover this in real time when we went through it that day, but we are going to take a look at exactly what the court said to Bryan Kohberger, exactly how Bryan Kohberger responded, and take a look at when you waive your right to appeal, is there any way around that? Because that's our next question. All right. A few of you have asked in the chat, would elocution have stopped this? No. Because he can still claim IAC. So you can still claim IAC. And he has the right to make an allocution or not. So let's get into this plea hearing from July 2nd, 2025.
Stephen Hitler, presiding judge.
I'm going to turn this up a little bit. I don't think our closed caption is going to cover anybody's face. This happened very quickly. The court sent this very quickly. Happy Day said, you're incorrect. The prosecutors went to the defense with the plea offer. I'm not incorrect on that. But if you want to cite sources, please do. But the defense went to the prosecution for this plea, not the other way around. Once it came to the prosecution, then they took it to the families. But this started with the defense on that. But if you would like to cite me to a source and a primary source, I'm happy to take a look at it. But the defense went to the prosecution on this. And yes, this is how Judge H started this hearing. Then again, Judge H started this whole case with, I would like to tell you I'm happy to be here today, but let's not begin with an untruth. He was reviewing all the file documents.
This is CR0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and
that's a lot of attorneys on the state's
here as
side.
well. Might miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms. Allen is here as well. Very well, thank you.
And remember, the prosecuting side of the table on this had attorneys from the Latah County Prosecutor's Office. They also had attorneys from the state's Attorney General Office. So I think we could see attorneys from either on this.
All right, we are here, change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case.
Oh, I forgot about that. I forgot that this started with Judge H scolding the internet. I believe it was, I believe that people were asking the court to deny this plea and go to trial.
This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants
He was real mad.
are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's
so
also
pissed.
highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me. Period. I have not
That's the
read
job.
any of the numerous messages nor listened to any of the numerous
Oh,
voicemails
God.
that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask
boy.
that you not continue to mount such campaigns or to send me information like this, because, again, it is not appropriate and, frankly, not something I would take into account.
Just, it's real simple. Don't go real world. Just don't go real world. Don't go real world with people. Don't go real world. That's all.
When deciding
Just don't do that.
a matter in a case like this, I
not
also
the right
want people
form.
to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is.
Oh, I could have just skipped to this. He talks about the rules of government in his speech. I completely forgot about his soliloquy. I forgot about that. And the thing is, in this case, I think people were trying to help, but it makes it worse.
The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently.
Right.
If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. If I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime.
Which is an important note at the time, because I think people were calling on the judge to not accept the plea deal. And the judge is informing really the public in this point, informing the public that there are very limited grounds where he doesn't accept a plea deal and that are legally proper for him to not accept a plea deal. So that's what he's basically speaking to the public on this, not the attorneys, because the attorneys all know this.
That is, I can ensure what is called a factual basis to the plea.
And they did take a factual basis.
Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July.
That's a lot of people.
With the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this getting this trial potentially underway on time.
Right. If they get through this plea, which we know didn't happen, but if they get through this plea and they get to, are you satisfied with your representation? And Koberger's like, no, I'm not. Do you understand the terms of this plea? No, I don't. Defendants have changed their mind mid-plea. It happens. Then they need to send out all those questionnaires, and they needed to send them out like the following week to the thousands, and he says 10,000 citizens of the county to try to find a jury. So the court was also addressing any criticism of how quickly this went because it leaked that there was going to be a plea deal, and then they were in court days later. This happened incredibly fast.
And including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and
Without
expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards
You're right,
trial
Judge H.
at the
Emily
time
should have kept reading.
specified. And so that obviously required that we act quickly. And so some
Here we
folks
are.
may have not had the amount of time that we would otherwise allow for them to travel.
And I think one of the difficult things for victims' families is that this is in Boise. Not everybody is in and around Boise. So taking time for this happening so quickly didn't give everyone the opportunity to travel for the plea. The sentencing was put over till later in the month to allow everyone to travel. But no, not everyone could be there for the plea. And there was frustration with that as well.
Here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum,
And we just went through
the
that.
defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could.
So in theory, the court could have sentenced him to anything, but again, we knew that when he took this plea, it was going to be 4 consecutive sentences of life without the possibility of parole. But the court did have the opportunity to sentence him to less. We were not convinced that that was going to happen. So we'll see.
Impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
All right, if any of you are looking in the background, come on back. Come on back. Look at him and his attorney looking at each other. Just come on back. Just come on back. As Ann Taylor's answering this, he is not shaking his head. He does not look disgruntled. He does not seem fussed. They seem to be looking at each other like, yep, this is what we're doing. So take a look at that. Come on back. I rewound it because it doesn't seem that he is feeling any kind of way that he has to take this plea. So you let me know what you think. Because again, we watched this. It was such a whirlwind the day that we watched this. I think going back and looking at it is really helpful. And it looks to me like Koberger is nodding along.
It is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make?
Bit too, Matt,
obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any
truthful and accurate answers? They look like they are happy with this plea deal. It looks to me like Ann Taylor is smiling at him while they are doing this. It looks like he is nodding in agreement that this is what they are doing. And while the court's going to read the transcript of this or have this hearing, Judge Hippler can remember these things because he is the one that's going to be hearing this when it comes to hearing. So I backed it up a little bit.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Truthful and accurate answers. He's not looking at her questioningly going, you said the truth didn't matter. How many times have we seen attorneys, not even around a plea, say, I need more time with my client. My client needs more time to talk to me. There is no back and forth in court right now.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Koberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that you understand, so that I am.
I would guess in that moment, because we're going to back up, because now I'm just watching the interaction between Ann Taylor and Bryan Kohberger. But as we back up, it looked to me like he was asking her, and this is me reading into it, it looked to me like he was asking her, do I answer the judge now? Because the judge shifts to Mr. Koberger, and it looks like he's asking, do I talk now?
About those.
Yes,
Do you consent to the entry of the plea today?
I do.
So when he turns to
Mr.
Koberger,
Koberger, I need to ask you some questions this afternoon, or I guess it's this morning still.
it looks to me like he's confirming, now I talk now. Right? I talk to the judge now. I answer now. That's what it looks like. So we'll see.
I do this to ensure that you understand, so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily. And I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right. Thank you. And now while you're standing, actually, why don't...
Okay, he may have asked if he stands up or if he answers. That's fair. Do I stand up? Do I not stand up? But listen to what the judge said. The judge put all the waivers on the table and now is like, all right, let's have a conversation. Super clear from the court.
You take the oath from the clerk.
He is being sworn in. This is a sworn statement under oath.
Do you solemnly swear or affirm that the testimony you shall give in the matter now connected in the court this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And Mr. Koberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated. All right. Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right. I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that are...
You heard the plea agreement. Do you agree with it? Yes. Mm-hmm.
That you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Well, that's what happened in court. We're going to keep going through this plea hearing, but the judge is going through all of the different waivers that need to be taken. And again, for those of you just coming in, hey, we're going to get to questions after this. But for those of you just coming in, Koberger's asking to withdraw his guilty plea. He waived his right to appeal. There are very limited and narrow circumstances where this would even be considered. Ineffective assistance of counsel, and that the waiver was not knowing, intelligently, and voluntarily given. Those are the circumstances. And he is saying that this is essentially both, that it was ineffective assistance and his waiver was not knowing, intelligently, and voluntarily given. He's alleging that he was threatened, though he also says that that's related to maybe an improper picture of what prison life would be like being painted by his attorneys. But he is saying that he was threatened and that he was coerced by disinformation to enter into this plea. So we will talk about what happens next after we go through this. But he is answering very clearly, concisely, and confidently. And that very narrow avenue of not a knowing, voluntary, and intelligent waiver is going to be a difficult bar to cross, because the judge is going to look at all of these waivers and said, you answered these under oath. And that's period. And then when we get to the IAC, there may be a hearing about that. So we'll see. But we'll get there after this.
Has anyone told you to be untruthful in answering my questions today?
No.
That's directly on point. I'm going to back this up. That's directly on point. That's directly on point to what he's saying.
Threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
It's pretty clear.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Koberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
I am satisfied with
Has
my
your
care.
attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered?
These are the documents I went over before we got to rewatching the plea hearing. I'm so glad that we did, because the plea hearing, the plea form doesn't say signed under penalty of perjury. The court went back through and held them each up. You signed this. You understood. You agree with what these say. So even though it doesn't have a signed under penalty of perjury, he is under oath now stating that he read those, he signed those, and he agrees with those. The judge is covering just about everything that you can. I don't see anything that the judge is, well, let's get to the end of this, but there's nothing that Judge H left out of this.
Answered in this document.
So I'm going to back that up just a little bit because I interrupted.
Have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to...
So a number of you are asking, isn't this pretty standard in a plea hearing? Some pleas, all the rights are lumped together, and then the defendant says yes at the end. Here, the judge is asking right by right, waiver by waiver for the defendant to answer. So some plea hearings can go faster than others, but when you are looking at, there's a difference between pleading to driving on a suspended license versus pleading to 4 counts of capital murder. So I'm not surprised that the judge is going question by question by question. And one of the things that the judge will consider if this gets there is looking at knowing voluntarily and intelligently waived. They will look a bit at his background, his education, and the way he interacted with the court here. Clearly, without questioning, and having said, yes, I had enough time to talk to my attorney. Yes, I signed this. Yes, I read this. And that's going to be a hard hurdle. And he's not saying he didn't understand. He's saying that he was coerced and threatened, and that's why it wasn't knowing and voluntary.
Remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
So that's a second waiver.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to.
Not all courts go through this part in this way. So this is in addition to kind of your standard plea. This is what the state would have needed to prove.
Had you, if you didn't plead guilty, let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Goncalves, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
That's not your feed.
I want to also
court
make,
paused to
for
look
the
at
record,
his filings.
the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
Did you agree with the written factual basis? Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
And now the court is going back through the factual basis. So this is a factual basis plea. I have seen some questions about, would this be different if there had been more of an allocution? But there is a factual basis here. It is the same. They can't, and we'll, I think, hear the prosecutor talk about it. They can't necessarily ask him, why did you do the things, and be confident that that would even be truthful. But he's admitting to each element of the crime. I did this thing with this intent. I did this thing with this intent. So there is a factual basis here. So it doesn't change the plea, whether he would have said why or not. Because again, you can't even, rely on anything that he might have said. So this factual basis is what they're going through now. Lola, we went over the actual plea agreement before we started this. So this is a factual basis plea. He is admitting to each fact that forms the basis of his plea.
Did you, on November 13th, 2022, in Latah,
And let me just back that up so we can cover him admitting to each crime separately without me interrupting.
on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Goncalves, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may.
So the court just went through the factual basis, and the factual basis asking Bryan Kohberger, did you enter the residence with the intent to kill within the residence? Did you kill each of the victims? And did you kill each of the victims with malice aforethought? So did you do all the things that makes this a capital murder? And he answered yes to each of those. That is the factual basis part of the plea. And then the prosecution is putting on the record what they believe their case would have shown had they gone to trial. So keeping in mind, this is different than when we've seen plea deals or we've seen pleas being taken where the defense attorney doesn't agree with the plea being taken. I imagine for the defense, it's a hard day to gear up for trial and be ready to fight for trial and then have it all come to a kind of abrupt end knowing that somebody's going to prison for life, just period. But we saw the way that this was handled in the Young Thug case when his attorney is like, I don't agree with this plea. My client has the right to make this decision. I don't agree. I don't want him to take this plea. I think it is a terrible idea. I don't want him to take this plea. And his attorney, Brian Steele, stood up and made a record that he disagreed with the plea. That's not what we're seeing here. And we're not seeing Bryan Kohberger ask questions of the court, ask questions of his counsel, have any hesitation at all. None. So for him to now say that this wasn't a knowing and voluntary waiver, just, okay, you can try that. I just don't think it's going to go very far. He may get a hearing with regard to the ineffective assistance of counsel claim. Maybe. But that still doesn't mean his plea will be withdrawn. It means that he will be heard and Ann Taylor will be heard and possibly other witnesses. And that the state has room to argue that they should also be a part of that hearing because his family was apparently part of these conversations. So there might be another hearing regarding that. But I don't think that means that this is going to get withdrawn. I think there is a very, very, very narrow chance that that happens based on what we know today. But does he still get to make this filing? Sure. Might he get a hearing with regard to ineffective assistance of counsel? Maybe. Do I think we're going to see a new trial on this? I think it's unlikely. But were that to happen down the road, this is going to cost the state of Idaho millions. And I would be surprised. But again, I've stuck to what's in the court filings. I haven't gone through all the unsealed evidence, and I don't know all of the information that Koberger seems to be referencing. But again, it doesn't matter what information comes to him. It's whether his attorneys did something wrong. And that is a different standard than whatever may have been unsealed. But I have thoughts about that too. But we'll get there after this. The state's putting their factual basis on the record. So.
Your Honor, the organization of the resuscitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing in his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Koberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Koberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Koberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Koberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Koberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m.
That's within the court. For all of you that are just getting an echo, it's within the court recording. It goes away to the best of my memory, but that's within the court. Because the court, remember, Idaho did not allow media in the courtroom to record this. Idaho said, you can use our in-court, we're using our in-court cameras, we're putting this out on our own Zoom through YouTube, and that was it. So this is on the court end, not y'all's.
Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman
I
Highway,
know, it's annoying.
just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Kaylee Goncalves. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel.
The reason he said single source male DNA multiple times is because at the time there had been lots of conversation around whether or not it could have been transferred DNA or what have you. When DNA is transferred, it is not single source. It becomes mixed. So there was conversation about that. I think that's why he said it multiple times when he was giving the state's recitation of at trial, we would prove this.
Was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed-blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen to where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom were to see that, you can see the car almost loses control as it makes the corner.
Well, doesn't the court have an investigation into a bunch of us seeing it because somehow it all got leaked to whatever program had all the never before seen stuff? We still don't know what happened with that investigation, but there was an investigation going into the leak of that information. But yeah, it's been since seen. It might have been seen before this. But yeah, the videos got out there. There's more out there now, but the videos got out there.
Heads north and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Koberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up.
Which gives timing
The defendant's
and
phone
context.
then went to the Lewis
Is what they were
and
gonna use it
Clarkson
for.
Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders.
Right.
The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Koberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the survey.
Right. If the vehicle has a front license plate, then it looks different, doesn't it?
The surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Koberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Koberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI who assisted.
I am disappointed they don't call it a dumpster dive, but it is what it is.
The FBI!
Continuing through the state's background.
Immensely with this case. Working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant
And then they
was issued
connected
here
that
in
back
Idaho,
from
and
the
a search
IGG
warrant
that
was
we heard
issued
so
in the
much
state
about.
of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Koberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him,
Right.
and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court and the public, the weapon itself, the knife, has not yet been recovered. I
We
can
knew
tell the
that.
court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there.
So
Nothing of
sparse.
evidentiary value was found. And of course, we're now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Koberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogen, Kaylee Goncalves, Ethan Chapin, and Santa Colonel. Thank you.
Thank you.
The other prosecutors are aware of the break in.
All right,
The
based on
prosecutor's
the
voice.
state's proffer and importantly, based upon
Getting
defense.
ready for trial in a case, in any case, is an emotional endeavor. Getting ready for trial in a case like this is on a different level from that, and you can see that in the prosecutor's statements there. So, the court's going to finish up this plea hearing that we are revisiting from last year. I can't believe it's been that long, but yeah, there's weight to that. So that doesn't really surprise me. Because again, everyone involved in the criminal justice system are people, and there's heaviness to it. So, getting back to the finality of the plea hearing here, let's take a look.
Defendant's explicit admission to committing these crimes, the court
Based on the defendant's explicit admission to committing these crimes. Commission was the word that was going to come out, but explicit admission. Right.
All right. Based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Koberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Goncalves, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Entin, a human being, how do you plead, guilty or not guilty?
Guilty.
The court will find
And
that
that's
the
it.
defendant understands the nature of the charges and
This
each
part-
offense.
This part matters too. The court's findings. The defendant understands the nature of the charges, each offense, and has admitted to them.
The defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. Court finds that there is a factual basis for the plea and finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor.
All right. As they get into the business of figuring out the sentencing date, which we have already watched, we're going to move on. The court has taken the plea, entered the plea, found that the plea was knowingly and voluntarily entered into, that the defendant waived his rights for appeal, and then this is going to be set over for a sentencing date. The last thing that we have not looked at that I think might be helpful to take a look at before we just answer questions is the defendant's signed plea agreement. We looked at the signed factual basis. We looked at the signed plea agreement. We did not look at the signed plea agreement and waivers. So that's the last thing that we haven't covered. And as we were listening to this, I thought it might be helpful to go back and look at the last document that we did not take a look at because, well, we're here to look at the documents and answer the questions about whether Bryan Kohberger can withdraw his plea or not. The answer to that is still, it's a bold strategy. It's a bold strategy there. I don't think that's going to go so well for Bryan Kohberger, but he's going to try. Let's take a look at that last document. This was filed July 2nd, 2025. It is the full plea and waiver. Xana B in the chat, you're not the only one who asked. A number of you asked, why is the court identifying each victim as a human being? It is in the language of the plea. It's in the language of the law, and it's in all of the language of the charges. So they are following the languaging of the charges there. So that is why. It is following the way the charges are written. Why Idaho has that specified exactly would be in their legislative intent. I do not know. But that's not uncommon. Most jurisdictions, depending on what other laws may be on the books, have that so designated. All right. This is filled out by Bryan Kohberger back in 2025 before the plea. Statement of Constitutional Rights. And it is a listing of each of the constitutional rights that are checked and signed by Bryan Kohberger, in addition to the other paperwork that we have watched, that I have covered today. We've covered the factual basis where he said, yes, I committed all of these crimes. We have covered the plea agreement. Yes, this is the plea agreement. I agree. And we are covering the written waiver in addition to the verbal waiver that the court took. So this is on top of what the court did. So he is going through each of his rights. The right to remain silent, that's number 2. The first one is the state cannot call you as a witness. You can choose to testify. You understand that by pleading guilty, you are waiving the right to remain silent as to the elements of the crimes to which I am entering this plea. Initialed by Bryan Kohberger. The next one, he checks the box. I understand that by pleading guilty in this case, I still have the right to remain silent with respect to any other crimes and with respect to answering questions or providing information that may increase my sentence. And then the next one, he went to go fill out and then put not applicable and scribbled it out. Number 3, you have the right to be represented by an attorney. Signed. You are presumed innocent. You will be found guilty if you plead guilty in front of the judge. Or if you're found guilty at trial, you understand that by pleading guilty, you are waiving the presumption of innocence. Signed. Waiving your right to a speedy and public trial. Signed. Waiving your right to confront the witnesses against me and present witnesses in my defense. Signed. The state has the burden of proving guilty beyond a reasonable doubt. That should actually say guilt beyond a reasonable doubt, but whatever. Emily, we are not editing the documents as we go. This is the state form. Saying guilt beyond a reasonable doubt would probably cause confusion for someone. I understand that by pleading guilty, I am waiving my right to require the state to prove my guilt beyond a reasonable doubt. Signed. Questions regarding ability to enter a plea. Do you read and write the English language? Yes. And again, if you don't and you need to have an interpreter, then the interpreter also signs an affidavit under penalty of perjury regarding going through this with someone who needs an interpreter. That doesn't apply here. And not only did he check no, he wrote not applicable next to it. He in fact modified it and wrote NA. Right. What is your true and legal name? Like, what's your full government? Bryan Kohberger. What is your highest level of school you completed? Master's level. I have my master's degree. If you did not complete high school, have you received the equivalent? He didn't answer that. Are you currently under the care of a mental health professional? No. Have you ever been diagnosed with a mental health disorder? Yes. If so, list the diagnoses. And then these all say February 2025. And he lists autism, OCD, ADHD, and ARFID, which we are not debating today. Those are the diagnoses that happened after he was arrested here prior to trial. Are you on any medications? Yes, and he lists it. If you answer yes, have you taken your medication in the past 24 hours? He said yes. In the last 48 hours, have you taken, if you answered yes, have you taken your prescription within the last 24 hours? Yes. In the last 48 hours, have you taken any medication or drugs, including over-the-counter, or have you consumed any alcoholic beverages which you believe to affect your ability to understand? And then he had signed yes and changed it to no. And I think that him changing it to no is his, honestly, as full like ADHD moment. I would be like, well, you just asked me if I took my prescription medication in the last 24 hours. And I said, yes, because I have. But does this question mean my prescription, or is this meaning everything but my prescription? I would have done the same thing. Like, I would have done the same thing. Either way, he says, no, he hasn't taken anything other than his prescription medication above. Are you under the influence of alcohol, drugs, or other medication at this time other than listed above? No. Are you capable of understanding these proceedings? Yes. And I think he's also capable of overthinking the question the exact same way that most of us would overthink the question. He's analyzing it in addition to answering it. Do you claim that you are mentally incapable of understanding these proceedings and what it means to plead guilty to a crime? No. Is there anything going on in your life that affects your ability to voluntarily plead guilty? No. Like, I don't know. Have your attorneys been threatening you like that? You mean if that there's a lot going on in my life right now? It asks it in a pretty neutral way. Is there anything going on in your life that affects your ability to enter a guilty plea? No. Are you having any difficulty in understanding what you are doing and filling out this form? No. Is there any other reason that you cannot make a reasoned and informed decision in this case? No. Plea agreement. Is your guilty plea the result of a plea agreement? Yes. If so, what are the terms? See attached. If a written plea agreement was done, have you read the plea agreement? Yes. Do you understand the plea agreement? Yes. There are two types of plea agreements. Please initial the one paragraph below which describes the type of plea agreement. And then he initialed the non-binding one that the judge talked about. Has your attorney or anyone else forced or coerced you in any way into accepting this plea? No. That's the exact language. Has your attorney or anyone else forced or coerced you in any way into accepting this plea agreement? No. Have any other promises been made to you that have influenced your decision to plead guilty? No. That's the exact opposite of what he's saying now. Has anyone told you what your sentence will be? Yes. If so, what have you been promised? 4 fixed life sentences consecutive and without the potential for parole, as well as 10 years. Sure. Appellate rights. Is this a conditional guilty plea in which you are reserving your right to appeal any specified adverse ruling? No. What rulings have you reserved the right to appeal? None. Are you waiving your appellate rights? If it is not a conditional plea, do you understand that by pleading guilty, you are waiving your right to appeal any ruling made by the judge prior to entering your guilty plea? Yes. Have you waived your right to appeal your sentence as part of your plea agreement? Yes. Potential sentences. And then he lists them in his own writing. I am charged with the crimes of count 1, and then he lists the crime, burglary, and the code. And then the rest of the counts, murder. And then he lists that he understands that as to the burglary, it's 10 years, and as to the murder, it's a fixed life sentence. But wait, it continues. If you plead to more than one crime, do you understand that your sentences for each crime could be ordered to be served either concurrently at the same time or consecutively, one after the other? Yes. Do you understand that if you plead guilty and you commit crimes in the future, this conviction could be considered in the future case and could cause more severe penalty in the future case? Yes. Are you currently on probation or parole? No. Then it's questions regarding that. And you know what he did? He skipped it. He's not just going through and checking boxes. He skipped the next question because it doesn't apply, because it has to do with if you're on probation or parole. So he is processing this to know that you don't need to just go through and check yes, yes, no, no, because he skipped that answer. They asked him about his immigration consequences. Would he be required to register as a sex offender? Which he said no. That there may be restitution. He said yes. Are you pleading guilty for a crime for which you may be required to pay the costs of prosecution and investigation? He answered no. He skipped the next question because it didn't apply. Have you agreed to pay restitution as a condition of your plea? Yes. Do you understand that you cannot withdraw your guilty plea even if the restitution amount is determined to be higher than you thought it might or should be? Yes. Is your license Is a license suspension required as a result of a guilty plea in this case? No. These are all checked by him. His attorney might be there with him while he's doing this and probably would be, but he's still going through it. Do you understand that if you plead guilty, you will be required to submit a DNA sample? Yes. Are you pleading guilty for a crime for which the court could impose a civil penalty? Yes. Do you understand that if you plead guilty to a felony, you will lose your right to vote in Idaho? Yes. Do you understand that if you plead guilty to a felony, you will lose your right to hold public office? Yes. Lose your right to perform jury service? Yes. Lose your right to have firearms? Yes. You heard the judge read all these to him in court as well. Do you understand that by pleading guilty to a felony, you run the risk that if you have new felony charges in the future, you could be charged as a persistent violator? Yes. Relationship with your attorney is the next heading. Have you had sufficient time to discuss your case with your attorney? Yes. Have you had adequate time to fill out this form? Yes. Have you had adequate access to your attorney's assistance in filling out this form? Yes. Your attorney can obtain various items from the prosecutor relating to your case. This may include police reports, witness statements, tape recordings, photographs, reports of scientific testing, etc. This is called discovery. Have you had the opportunity to review the discovery provided by your attorney? Yes. Do you want your attorney to take any further action in this case? No. If you are not a citizen of the United States, have you talked to your attorney about immigration consequences? He had ticked yes, and then he scribbled it out and said not applicable and initialed it, probably because there won't be immigration consequences because his citizenship is of the US, so it's not an issue. Do you understand that no one, including your attorney, can force you to plead guilty in this case? Yes. Are you satisfied with your attorney's representation? Yes. And then what's below it? If not, state why you are dissatisfied. Any concerns with your attorney? Put it in the box. Do you understand that by pleading guilty, you will waive or give up any defenses, both factual and legal, that you believe you may have in this case? Yes. If your guilty plea is the result of a plea agreement reached through mediation, did you voluntarily enter mediation? No. Did anyone force or coerce you to enter mediation? No. Are you satisfied with the conduct of the mediation? Not applicable because there was no mediation. Entry of plea. Are there answers throughout this form? Are the answers throughout this form your own answers? Yes. Are you entering your plea freely and voluntarily? Yes. Are you admitting all of the elements of the crime to which you are pleading guilty? Yes. Or it says, are you pleading guilty because you are entering an Alford plea? No. And again, he wasn't under this plea agreement, an Alford plea or a plea saying I'm pleading guilty because it's in my best interest, but I'm not admitting that I did it, was not available to him. And then the next question's about an Alford plea. He writes that it's not applicable and doesn't fill it out. Have you had any trouble answering any of the questions in this form which you could not resolve by discussing the issue with your attorney? No. The next one's asking about an interpreter. He says not applicable because it's not. Do you need additional time before you enter your guilty pleas? No. Do you understand that if the court accepts your guilty plea, that you will not be able to withdraw your plea at a later date? Yes. Is there anything else you want to tell the court about why you are pleading guilty? No. Have you discussed the elements of the offense for which you are charged with your attorney? Yes. And then there's a full under penalty of perjury section. I have answered the questions on pages 1 through 7 of this guilty plea advisory form truthfully. I understand all of the questions and answers herein. I have had an opportunity to discuss each question and answer with my attorney, and I have completed this form freely and voluntarily. And then this is in bold in all caps. With a complete understanding of the charges to which I am pleading guilty and with knowledge of the potential consequences of this plea. Furthermore, no one has forced me or threatened me to plead guilty. Signed by the defendant, name printed by the defendant, dated June 29th, 2025, a few days before he actually went and pled. It's not as if he was rushing through this in the courthouse before he was pulled into court. He pled on July 2nd. This was filled out June 29th. He still had a few days to sleep on it. And then signed by all of the attorneys. 3 attorneys signed this with him. Not 1 attorney, 3 attorneys. Post plea rights. We're not done yet, chat. Post plea rights. A pre-sentence investigation will be ordered by the court unless both you and the state waive the report and the court approves the waiver. If waived, you will not be eligible for probation. It doesn't matter. He's not eligible for probation anyway. The court may order evaluations as part of this investigation, and these reports will be used to determine your sentence. Unless you have waived the right to remain silent as part of your plea agreement, you have the right to remain silent during all proceedings and interviews from now until your sentencing, all caps, which includes the pre-sentence investigation and any court-ordered evaluations. The information in the pre-sentence interview and any evaluations, which will include any statements you make in these processes, will be used by the court in determining your sentence. In particular, if you are ordered to undergo a psychosexual evaluation, which can include a polygraph examination, a domestic violence evaluation, a substance abuse evaluation, or a mental health examination, which can include a psychological or psychiatric examination, you will be asked extensive questions, and your answer to those questions may be used during sentencing. Have you discussed your right to remain silent with your attorney? Yes. Do you understand the nature of this right? Yes. Do you understand that you may waive this right? Yes. Have you waived any of this right in your plea agreement? Yes. Do you have any questions concerning either this right or the waiver of these rights? No. Have you discussed with your attorney the rights regarding your attorney's attendance and presence during the pre-sentence investigation or the various evaluations? Yes. Do you want the court to order any particular evaluations to assist the court in determining a sentence in this case? No. But then there's room for him to fill it out if there's something that he wants to do. This was signed June 29th, signed by Bryan Kohberger, named by Bryan Kohberger. So, what have we gone through today before we just chat? What have we gone through today? We have gone through Bryan Kohberger's interview with the New York Times over the weekend, his statement to the New York Times that innocence is his truth. We have gone through his written motion, because in custody, so written motion for post-conviction relief. That post-conviction relief sets up or branches off into a separate case where it's now Bryan Kohberger versus the state of Idaho. The judge set for that at the moment is Judge Hippler. That can change. All of this was just filed on Monday, July 27th. So let's finish going. What could be more egregious? I'm kidding. Every time I say what. So now, what else did we go through? Interview and statement. The docket that we saw for the new case. We went through Bryan Kohberger's written motion requesting appointment of counsel. We did not go through his motion asking for a fee waiver. He's asking for a fee waiver, saying he doesn't have the money to hire his own attorney. We went through the entirety of his filing seeking post-conviction relief. That post-conviction relief would be a withdrawal of his plea. He has not withdrawn his plea yet. That has to be approved by the court. He waived his appeal rights. This is him seeking post-conviction relief, slightly different than an appeal, but also there is very narrow circumstance where this could happen. That very narrow circumstance is either ineffective assistance of counsel, which he has alleged, or that his plea was not given knowingly, voluntarily, or freely. And he's alleging that his plea was not given knowingly, voluntarily, or freely because he was promised things that did not come to fruition and that he was threatened. So, where does that all go? Well, I think given everything that we have looked at today with the written waivers, the verbal waivers in court and the rest of it, he's got a very, very difficult battle to prove that this was not a knowing and voluntary waiver. I don't know if the court will even entertain those arguments. The court may allow for a hearing with regard to whether or not there was ineffective assistance of counsel here. What would that look like? Well, I think there's a pretty solid argument that that should be a public hearing based on what Bryan Kohberger put in his own filings, saying that his family was present during these discussions. That means attorney-client privilege can be waived or has been waived. So I think there's an argument that that could be a public hearing. However, when we see most often hearings that regard attorney-client privileged information like ineffective assistance of counsel in conversations, most of the time those are without the prosecution and without the public. I think that might be different here based on what we've seen. We'll see. But the state will have an opportunity to respond. And Taylor is now a witness to this. If he is appointed counsel for this, it would have to be someone that is conflict-free. The family members that were present during these discussions could be witnesses to this. All of the defense attorneys would be witnesses in this. The prosecution or representative of the state, because it could be the attorney general's office, would have the opportunity to oppose this. And we will see where it goes. But is this going to move particularly swiftly? Probably not. Do I think that this will be ultimately successful? No. If it is successful, are there some problems here? Yes, because we have, and I mean, it is exceedingly unlikely that this would be successful. It's exceedingly unlikely. But in the 1 in a zillion chance that that happens, you now have a circumstance where they've already changed venue in a case, and so much of the information that might have come out at trial comes out that I could see us ending up in a situation where the defense, if we ever got there, would start to argue that they can't get a fair trial because too much information's come out about the case. Because now we have information that's been unsealed. I can't really call it evidence because it wasn't submitted in court through a trial process, but you now have quite a lot that's been unsealed. You have quite a lot that has become public that wasn't public before. And now it sets up potentially an argument for not being able to find a jury because so much has come out. All of the motions that were sealed previously have been unsealed. There have been requests to different law enforcement agencies. Those requests have information that has come out. We haven't covered a lot of that because it's not active litigation that's going on in court. And the motions that were unsealed after the plea don't really impact this case one way or the other unless this shifts. And if that happens, then we can go back and revisit it. But for now, I think that this is I guess he maybe sees it as you got to try it. I would be very interested to see I'm interested to see what he perceives as the issue, but I even think some of his writing about this gives us a little bit of a insight into that, because he said promises were made regarding his housing, regarding being able to have visits and what have you. So it'll be really interesting to see how that shakes out, because that's not what the court are going to consider threats. I'm not going to expand on that much more because, well, we're not here to help. But the way that he went through what the threats and coercion were in his writing is really centered around and I'm looking at point 3 from his affidavit, a gross misrepresentation of and promises regarding what a life sentence would immediately afford petitioner, and a gross misrepresentation of death row in Idaho, including an elaborate fabricated story of counsel's horrific experiences touring an actual 8x8 death row cell, all communicated to petitioner and his family, allegedly by IDOC, which is the Department of Corrections, through counsel, thus constituting threats and promises made to induce a plea agreement. Even in this, it seems that he is saying that the threats and promises were regarding housing. That's not what the law means. That's not what is contemplated here, and that's not the circumstances where we will see this type of plea or any type of plea be withdrawn. I am curious to see where we get with the IAC claims. A lot of you were asking if I thought Ann Taylor would be big mad over this. I don't think she's going to be as surprised by this because it's part of the cycle of being a defense attorney, right? That your clients are going to do what they need to do in their own best interest. And it seems to me that some of this could be dealt with a housing complaint because he seems unhappy with prison. But I guess we'll have to see. I'm truly curious about the investigation into the leaked information. Like, I'm really, really curious about that. Are we ready to get to some questions? We'll see. Are we ready to get to some questions? Sure. Let's get to some questions because the headlines have just been so wrong on this. It's just frustrating. But at the end of the day, for those of you just coming in, where are we at? No, Bryan Kohberger has not withdrawn his plea. That is the remedy he is seeking for post-conviction relief. He is going to have to establish that either there was ineffective assistance of counsel or that his plea was not given knowingly, voluntarily, or intelligently. He has a significant and substantial uphill battle. The IAC claim could require a hearing. I don't even know if we'll see much daylight given to the knowing, voluntary, and what was the other one? All the three. I don't think the knowing voluntary waiver is going to get much attention here. I think the court's going to be like, no, this was a intelligent, knowing, and voluntary waiver of your rights. So the IAC claims might get vetted. What is that not? The IAC claims are not since the stuff has been unsealed, there's more information here, or people have new discovery there. None of that is what is at issue here. What's at issue here is whether or not there was ineffective assistance of counsel. And the basis for those claims, he is saying that he was not provided with he says exculpatory, but potentially exculpatory evidence. But that's not quite squarely the question. Because when it comes to the plea, the question of ineffective assistance of counsel really boils down more to, did you know what you were pleading to? Did you know what you were going to present at trial? Do you know what your rights are? Do you know what the state would have to prove? This is not a rehashing of whatever evidence might have been presented at trial and the sufficiency of that evidence. That's not the question here. The question here is, was he properly advised going into this plea, and how did that all go down, and what were those conversations? And that is really where we're going to see the focus of the conversation here. Hopefully that makes sense. So let's get into questions. You've got questions, I've got questions, we've got questions. Let's get into questions. Lots of questions. So my kid's personal Uber driver asked, is he representing himself with this at this point? Because he doesn't have an attorney, but he's also asking for counsel. So he's asking for counsel. So we will see. R. Hampy said, question, how many plea deals did you do without an allocution? Seems very odd to not have required it in this case. I think there is just a misunderstanding, and R. Hampy, this is not criticism to you. I think there's a misunderstanding about factual basis pleas, and I don't know where the colloquial misunderstanding is coming from, because it's odd to me. So I'm not sure where the misunderstanding is, but the factual basis is not really different than an allocution, but people colloquially will use allocution for like when a defendant has a right to make a statement at sentencing. But there was a factual basis here where Koberger admitted to the elements of the offense, and that really is it really serves the same purpose of an allocution, but you can't force a defendant to go beyond and in their own words say a more detailed factual basis of I went into the house at exactly this time and I opened the door with my right hand versus my left hand. You can't do that level of required, I guess, allocution if that's what's being referenced. But this was a factual basis plea, and most pleas are factual basis. This is the factual basis of your plea. These are the things they're alleging that you did. It is the what, not necessarily the how, if that makes sense. So can you require a defendant to put their crime in their own words? Not in every jurisdiction. And it's not often done at every plea. Even in federal, where there is a factual basis that is much more detailed and specific, that's generally written out ahead of time. Sometimes the defendant reads it in, sometimes they don't. But a factual basis plea is perfectly sufficient, and having the defendant read it in his own words versus saying yes wouldn't have changed things. So again, it's difficult when I think people are using the word allocution to mean colloquially like you have to require the defendant to give every detail of the crime and to say everything that they did, but that's not accurate. Also, Idaho uses a factual basis, and a factual basis is perfectly sufficient. But yes, you need a factual basis for a plea. Here they had that. So do you need the defendant to put it in their own words? Not necessarily. So hopefully that makes sense. I just don't understand. I guess I'm not quite sure where it's coming from, because in the context of a plea, I don't see the two as being mutually exclusive. Like whether the defendant puts it in his own words versus whether or not the court says, did you commit the elements of this offense? It's not substantially different to me. But in a lot of jurisdictions, you can't require the defendant to do much more than answer yes or no questions. So hopefully that makes sense, but I'm not quite sure where that confusion comes from, but I'm glad you asked the question. You're not the only one. Many asked that question. I'm just not sure, because there's requiring the defendant to say it in their own words is not more valid than the factual basis plea that we saw. And that's the factual basis that we saw. And the defendant said that he did each element of the crime, which was enter the home to commit a murder, and then committed 4 murders of the victims with premeditation. And then when the court said, are you pleading guilty because you're in fact guilty? He said yes. So that is a sufficient factual basis. And him saying those things in his own words versus answering yes to the court changes nothing in this case, if that helps. So hopefully that breakdown helps. Let's see. Woman of Steel said, if Koberger gets a new trial, will a change of venue be required? A change of venue wouldn't be his biggest problem. Koberger's biggest problem is that if for some reason, and I'm not saying this, and God, if anybody says EDB said he's going to get a new trial, I will lose my mind. On the farthest out possibility that we are in an alternate dimension where another trial happens, please keep in mind that his waiver of his Fifth Amendment rights includes his plea. So his plea can be used against him in the future. So there's also that. It's not just, it's not as if there was a plea negotiation that fell through and it can't be used against you. This isn't like a transactional or use immunity where you have a conversation with the prosecutors and then they decide to prosecute you and they can't use what you said against you. They can use what he said against him. So, let's see. Jen, the law nerd, said, doesn't he realize that in the event he's allowed to withdraw his plea, the firing squad goes back on the table? He said that he was fine with that. So he said that he was fine with that in his statement to the New York Times that we covered at the beginning. I don't know what the goal here is, but I also don't try to read into motive. He has the ability to file this, and so he chose to file it. We'll see what happens. Interesting choice to put his attorney on blast. I don't think it's going to be successful. However, he's got nothing else to do. So he's got time. I also don't know, because I have not followed this case post-plea. I don't, other than the Ann Taylor versus the expert that apparently wrote the book and was making statements in public, I don't know what other information there is, but I could, if he is consuming that information, you can see why somebody would be like, you know what, let's do this. So, sure. We'll see. Let's see. Trisha asked again about the allocution. I think I've answered it pretty thoroughly. No, the factual basis is more than sufficient, and all pleas need a factual basis. But the factual basis is more than sufficient. Let's see. Treasure said, conflicted with legal curiosity versus moral disgust. I understand that. I mean, we're just going to keep watching what unfolds in court. It's going to take some time, but we're going to keep watching what unfolds in court. If there is an attempt to have this hearing private, I think there's a really interesting argument about whether or not he waived attorney-client privilege by having his family present, if they were in fact present. Of course, that assumes that his statements to the court were true. So we'll see. Becca asked, Emily, so it is possible. It's possible for him to file this motion. The hurdles that he has to obtain the post-conviction relief he is seeking are substantial, and it makes that incredibly unlikely. But it's possible for him to file the motion. So there's that. LMD said, can't wait for EDB's take on this. I think it's going to be a lot of court time and possibly an appointed attorney for, I don't know, for a maybe a hearing. And if the information comes out at the hearing that his attorneys were in fact threatening him and lying to him and abusive to him, then I think my view on it will probably change. I just find that incredibly unlikely. And I've, again, worked in the criminal system long enough to see a lot of defendants say things like, but my attorney made promises to me, man. And what the attorney said was, hey, I can ask the judge for a request that you go to this housing location versus that housing location. And then the Department of Corrections said, the options are neither. And they're like, but my attorney promised. So I'm not, I guess, all that surprised by but my attorney made promises to me that the 8x8 cells on death row were not great. I don't think that's a threat. So, Woman of Steel said, doesn't he have to prove that? Yes, this is a motion where he bears the burden of proof. So, yeah, he bears the burden of proof on this. And we'll see. Jam, I'm so sorry. Jam said driving a mail truck in Maryland, it is so hot in here. I can only imagine. Thank you for the work that you do. And I am so sorry. It is not a great day for that. Janice said, finish my master's. Thanks to EDB for the inspo. Congratulations, Janice. It is undoubtedly incredibly rewarding. Congratulations to you. For the kids that started at the bottom, now we're here. Now we're back here. I mean, it's why things never fall off the docket. We just keep ending up back here. Allie said last night, Kevin Fixler of the Idaho Statesman disclosed that he and the New York Times journalist are writing a book about the case. Is that the same journalist that wrote this? Because I saw in the byline of the journalist on the article we read that he's writing a book about the case. I'm sure there will be many books written about the case. People have asked me to write books about cases I've covered. Notice there are no books. If we do that, we'll do it about something else. But yeah, there will be many books about all of these cases. Of course there will. There will be plenty. But yes. Kieran said, so what if he was threatened into the plea? He has to prove that. But if that's true and the plea was not fair and voluntary, then that is an avenue to have it withdrawn. That is a very, very difficult threshold to meet. And I think based on my reading of the affidavit, I am skeptical of whether there were actual threats, for sure. Deborah said, do you think his attorneys told him to do this? No, I don't. I don't think his attorneys told them to do this. I wonder if his attorneys, or they're not his attorneys anymore, because at the end of the case, they no longer represent him, but I don't foresee that one way or the other. It's possible that they said, look, the only potential avenue you have when they were giving him advisement was if this wasn't a free and voluntary waiver. But if his attorneys went into court thinking that he wasn't giving a free and voluntary plea, then there are really big ethical considerations and problems there. And I don't think we saw his attorney, other than when the court asked if she had had time to go through the discovery, because they had been back and forth on that quite a bit. We didn't see the defense say, no, we've not had enough time to do what we need to do, and I don't agree with this plea. And we've seen defense attorneys do that in other cases. Jojo asked if defense attorneys are also under the executive branch. In this context, yes. Madeline said, could this have been a strategy between Ann Taylor and Bryan Kohberger to give them more time for evidence gathering? No. I don't think that would be ethically proper at all, because if she did not believe that there was a factual basis for the plea, then saying yes in court on the record as an officer of the court saying that this plea can go forward would be a massive problem. So we will see. Let's see. I'm just trying to get to the questions because there's Iffy Fluffy said, God damn it, Koberger. in the voice of Carl, which I cannot do nearly as well as the voice actor who does the audiobooks for Dungeon Crawler Carl, but the all chat is just like, God damn it, Donut. Yeah, fair. Salty said the Princess Posse would never. Ugh, prison. How drab. Yes, it would never. It would never. The virtual juror said thesis defended from prison would be interesting. I could see it happening, though. You generally have access. I don't know how institutions would feel about it, but you generally have access. Who said Mongo is appalled? Mongo is appalled. Yes, Mongo would be appalled. Mongo would be appalled. Cole says, who notifies Ann Taylor that he filed this? Every single media outlet blowing up all of her work numbers, asking her for comment on this story is probably the first way she heard about it. But also when it's served on the state, I imagine the state would also forward it to her. But yes, I think that every journalist who was writing about this, including the New York Times, probably reached out to her and asked her to comment. So I imagine she heard about this before we did, because I would guess that the New York Times would have reached out to her when they were talking to him on Saturday or Sunday. She's not going to give comment on it. She can't waive attorney-client privilege, but a lot of you asked, and I'll reiterate it again for those of you that weren't here earlier. A lot of you asked, can she waive attorney-client privilege? She can't waive attorney-client privilege. However, in the context of a client like Koberger alleging that the lawyer has threatened them or is ineffective or what have you, the attorney can defend themselves. Sometimes that has to be a sealed hearing. Sometimes that has to be a sealed proceeding with the court. But the attorney is allowed to relay to the court what happened in those conversations. So there is room for the attorney to provide the other side of the conversation. The attorney is not rendered silent by that privilege, but it seems that Koberger has waived that privilege, and that's another caveat here. But I imagine that it was quite a lot of people reaching out to her. I would imagine that the other attorneys involved in this case, the other defense attorneys, also got hit up for comment, and they probably were all in a group text somewhere saying, well, do you think they were just sending Michael Scott memes of it's happening, stay calm, it's happening? Possibly. Do I think there's probably a group text? Probably. There's probably a group text of what's going on, because I imagine all of the attorneys had voicemails, emails, probably text messages to their work cell phones, etc. Yeah. Cheryl said she was probably asked to comment before it went to press. She was asked to comment by the New York Times, and I imagine others as well. So yes, I imagine every outlet who has an email address for Ann Taylor probably reached out to her. And then every outlet that might have had her work number has reached out to her on that too. Quite a lot. So yes, I think that's probably how she heard about this first. But I don't know if the state would even have copies of this yet. The state might have seen this through headlines before they got served a copy. It just depends on how fast the mail worked and how long prison mail takes to get out. So we'll see. We need Takes Evie Baxi on the soundboard. Maybe Takes Evie Baxi. Let's see. Will Newman said, I wonder if this has anything to do with the fact that there is a Netflix documentary going to be dropping tomorrow, Wednesday, about this case. I mean, I don't know. I imagine the producers at Netflix are just like, this couldn't happen at a better time. I mean, the producers at Netflix are fucking thrilled, but it sounds like there's another one. 3-part docuseries being released. Okay. I honestly, I wonder if the timing that matters more is that this was coming up on the 1-year anniversary of the sentencing, and that's the timing Koberger was looking at. Because remember, Koberger is not at this point represented by counsel. There's no reason for the public defender's office of Idaho to continue paying for counsel. He waived his appeal, right? So if he's doing his own research and trying to figure out whether or not he needs to file this at the 1-year date of the entry of sentencing, most, unless they're working with Mackenzie Shirilla, but most would take a look at the date of the sentencing and want to be ahead of the date of the sentencing hearing and not rely on the difference between the date of the sentencing hearing and if that didn't get file stamped by the judge until later with the restitution. I think that using the sentencing date as the deadline is the cautious and the proactive choice. So a lot of you are saying there was a September deadline. I think sometimes with those deadlines, there's room to argue. So I think the cautious answer is file it before the 1 year of the sentencing hearing in court. So I think I think that's cautious. I don't think necessarily Netflix has anything to do with it, but who knows? Maybe, maybe not. Look, we can look at what's filed in court. We can look at what happens in these cases, but what is Bryan Kohberger thinking when he files this? I don't know. I imagine at some level he's thinking, maybe this will work. Sassy said the AG of Idaho responded. Yes, we went over briefly the statement from the Attorney General in Idaho earlier when we were going over the New York Times article. They didn't respond to the motion. They gave a statement. But we can go over that statement again real quick. The statement that was in the New York Times article, Brian Entin also shared this on social. The Idaho Attorney General's statement regarding this case was, quote, "My heart goes out to the families of Madison, Kaylee, Xana, and Ethan, who have already endured unimaginable loss and now must face today's deeply painful news. My office stands ready to do whatever is necessary to ensure justice is fully carried out." That's it. Sassy Southern, no worries. I got you. Yeah, that's it. That's the entirety of the statement. It was in the New York Times article at the beginning. And then, I don't think we covered the full statement of the Goncalves family. Bryan Entin also shared the statement of the Goncalves family regarding Bryan Kohberger, but we can look at that real quick. The replay crew is going to be like, these timestamps are all over the place. Yeah. It's the ADHD. I'm not mad about it because I think that statement was a little bit shorter in the New York Times. So we can do the full one. Let's see. Hold on. Emily fights with technology. There we go. Wait, there it is. All right. This is from Brian Entin. I pulled it up on Twitter. I know it's called X. Honestly, I just don't care. Maybe that's rude, but it's Twitter. It just is. So, Goncalves family statement, quote, "The mosquito you just can't seem to swat. That is what Koberger and his following have become to this family. We read Mr. Baker's story. No relation. Just so we know. We read Mr. Baker's story. He must be so proud of himself for speaking with Mr. Koberger and his sister, giving them a platform to spread their narrative." I didn't see any statement from the sister in the story, unless it was talking about Bryan Kohberger, because there was a section that was talking about Bryan Kohberger's past and we just moved on, so it might be there. He must be so proud of himself for speaking with Mr. Koberger and his sister. Look, I'm not disagreeing with where a victim's family is coming from. Victims' families especially in high profile cases, have to navigate something that is so different and difficult that they are, in my mind, just entitled to feeling how they feel. I also don't hold it against journalists when they're like, oh, somebody from prison who's never spoken wants to speak with me about a thing. Of course they're going to do that. It just, I don't know. It kind of just is, right? Let's see. They go on to say he must be so proud of himself for speaking with Mr. Koberger and his sister, giving them a platform to spread their narrative. This piece had little else to offer beyond a guilty man once again claiming he is innocent. Nowhere in the story or in Koberger's own statement does he not acknowledge that he knowingly, voluntarily, and intelligently admitted to murdering the 4 victims of this tragedy, Kaylee, Maddie, Xana, and Ethan. Quite the opposite. He appeared in court for a hearing before a judge. Oh, I'm glad we covered this after because we just went back and watched this. Yeah, we just went back and watched this. Quite the opposite. He appeared in court for a hearing before a judge accompanied by his 4 lawyers. He chose not to leave his fate or the facts of this case to a jury. He never cried foul, never claimed he was uninformed or pressured, and never suggested that there were problems with the discovery materials he and his counsel had reviewed for 2 years that should have been challenged. He admitted his guilt. When asked whether he was actually guilty, he answered yes. All facts. He would have preferred a death penalty trial, this is from the victim's family. We would have preferred a death penalty trial. We believe fully in the evidence. Instead, Koberger received exactly what he asked for, a deal that spared his life. Knowing this, he hates that life. He wants another chance to roll the dice. There will almost certainly be a hearing. That is how the legal process works. The defendant will get another day in court, a welcome break from the solitary confinement, a ride perhaps, different food, photos taken, and the spotlight once again fixed on him and his supposed quote-unquote innocence. The real tragedy in this, if even a fraction of the energy spent trying to free a guilty man were directed toward honoring the victims, there would be statues. And this is the part that the New York Times put in, so if it sounds repetitive, this is the full statement from the Goncalves family, not the parts that were just in the New York Times article. But they say the real tragedy in this is even if a fraction of the energy spent trying to free a guilty man were directed towards honoring the victims, there would be statues of them in every corner, parks bearing their names, and days set aside to remember the lives they lost at the hands of a narcissist. And then that goes on to list 2 websites that are in the Goncalves family statement. One is murderhasaname.com, and the other one is a foundation, but I can't see the full foundation name. If we see that, I will add that, but I'm sure it's elsewhere. I just don't see it. So that is the statement that I pulled, the full statement from Bryan Entin on social. But yeah, for the families, I said at the beginning of this, when the plea was happening, that one of the considerations in taking a plea, even if some of the families don't want a plea to be taken, is that it eliminates the what if of appeals. It eliminates being locked in the constant loop of this case being at the forefront of your mind. And this pulls it back up. And that is something that is that has a cost to all of the families in this case, because it pulls all of it back up into the spotlight. Though if there's another docuseries coming out, because of how high profile this case is, it's going to keep coming up and keep pulling it into the spotlight. So, yeah. So whoever asked the question that reminded me that we hadn't covered this, thank you. I appreciate it. Because it got us back down to the statement that we didn't circle back through. But this is going to take some time. And it will go through the court process. I don't think it will go beyond that, but yeah, they're not wrong that it will break up the monotony of what life without parole looks like. Hospice RN, thank you for your work. Autumn. Emily, are your pillows made from the t-shirts? They are not made from the t-shirts. They are made from Team Baker to display our artwork for me. Can we get some in the shop, please? We have gotten many requests for it. When we can figure out a way to bring you something that does not have a ridiculous shipping cost and that we love, it is on our mind. You guys have let us know it is on our mind. So we have heard the requests. We will figure that out. We might down the road do it by a pre-order or something. But yes, it is on our minds. You have asked. J. Michael, good to see you in the chat. Miss the live streams. Jade says hi. Hi, Jade. I know life gets busy and summer is busy. And here we are. Bedtime stories with Bella Lugosi. That is a fantastic and niche screen name. And I'm here for it. Dr. B is going to be thrilled with us as well. Can Ann Taylor respond or would it break attorney-client privilege? Ann Taylor can respond. Some of that might be sealed, but not until this gets set for its next phases in the process. Like Ann Taylor can't just, or wouldn't just go to the New York Times and be like, everything that guy said is bullshit. But she does have process to respond in court. It is not uncommon that defendants have issue with their attorneys, even when there aren't issues to be had. So, this is not, it's not unusual. Let's see, I'm trying to get to a few more questions. Hopefully we answered all the questions or all the questions about what the actual issue is here. I saw a lot of questions about new evidence or what about this evidence? What about that evidence? What about this? That's not what it's about. Here, it's about whether there was ineffective assistance of counsel that impacted his plea. That's the question here. That's it. So, does it unearth everything? No. Whippet 2014 says, doesn't everything Turvey has done make him untouchable as an expert in the future, or will other lawyers care? Oh, I think lawyers will care very much. I said that when we covered it. I think it's a problem. He says, and again, we don't know everything, which is frustrating. He says that there is not an NDA. Ann Taylor says that there is. We covered it briefly when it was going on, but it really feels like a side quest of drama. And if it impacts this, then, I try to avoid the side quests of drama. But if this is beyond a side quest of drama, we might have to actually engage and figure out what is going on there. But I'm going to keep an eye on what gets filed in court, because that's where we ground things on what's filed in court, and we'll see. But at the time I said, this is not going to go well. Not going to go well at all for the expert, especially when the attorney is saying that he's commenting outside of what he was asked to do and outside of an NDA. That is a problem. JR said off topic. DCI is not off topic in the summer. Off topic, EDB, but my daughter is going to DCI Allentown this weekend. It's her first time going to DCI. Okay. I have not been to Allentown, but I imagine bug spray, hydration, the merch booths will always have lines. If you want to see stuff in the lot, you can kind of wander around near the venue to see who's warming up and where. Just kind of follow the noise and you'll find it. Have the best time ever. Have so much fun in Allentown. And it'll be great. So for those of you where's Allentown, Pennsylvania? It is kind of the last, not to disparage any other location for DCI, but it is a significant stop on the tour on the road to finals. It is significant. It's going to be hot. It's going to be hot, but enjoy. The Cavaliers show is so good. I love it. There are other shows I really enjoy, but I'm always going to be horribly biased in this because my kid marches Cavaliers and I've seen their show the most and I love it. I just love it. I love it so much. I love how it's grown. I love the show. I really enjoy the concept and execution of the Blue Devils show. I have not seen the Blue Coats show live, so I'm withholding on that. There is choreography in Boston's show that I don't even know how they're doing it. Santa Clara Vanguard has people jump roping blind while still blowing their horns. I don't know how anyone does that. But then again, I played drums and did guard. I don't know how anyone did that. It's a bold strategy. I don't know what their conditioning looked like to get them jumping up and down, playing their horns, but it's crazy. And then everything's a little Cirque du Soleil this year. We got a lot of people being lifted in the air. Just a lot of people being lifted in the air this year. The whole thing. My kid's personal Uber driver. Do the Cavs have the wheelie guy? Yes. The Cavaliers have the one wheel in their show. Tracy said, say what? Yeah, a lot of people lifted into the air. People are lifted into the air while they're playing instruments. People are lifted into the air while they are dancing. Just lots of people being hoisted into the air. Beloved ask, if a hearing is held, would Ann Taylor have to testify? If a hearing is held with regard to the IAC, one would expect that Ann Taylor would testify. Yes, she would kind of have to. But we'll see. Ali Foley said he wants the attention Rex is getting. I mean, everybody wants to be, no, Emily, not Rex Manning, Rex Huerman. It would not surprise me, and I would not fight you on the assertion that, well, he also wants to work with the FBI. That would not shock me, knowing what we know. Trumpet Mom, DCI. Emily, what are your thoughts on woodwind soloists? The fact that no one has done an epic saxophone solo is disappointing to my soul. Like, there are so many good saxophone solos. There was so much opportunity for just someone on a prop with a saxophone doing like Baker Street. I'm so sad. I want an epic saxophone solo, and there isn't one yet. But I think there's room for like literally the saxophones. So my thought on a woodwind soloist, I want saxophones. I love a flute soloist. I am fine with an oboe or whatever, but I really want to see an epic saxophone solo. And then I will be thrilled. That's what I'm waiting for. I'm waiting for that. So if they allow for a woodwind, because there's some music with some epic saxophone solos, let's do that. Let's just do that. Natalie Starr said, had no idea you can withdraw your plea after sentencing. It's very rare and limited. And you can ask for it. It doesn't mean it's going to happen. So you can ask. There are limited circumstances. One of the most common circumstances where you will see a plea withdrawn is if someone was not fully advised of the consequences of their plea. That is the most common circumstance where if their attorney forgot to advise them of a consequence of their plea, that a plea can be withdrawn. Can that happen? Yes. Can a plea be withdrawn for that? Yes. So it happens. But we will see where it goes from there. But that's the most common circumstance where you see a plea withdrawn, but it can happen. So we'll see. Rena Bouchard said, Emily, wait for the Vampire Lost Boys next year, epic sax. I'm waiting for it. Emily's just like waiting for like Lost Boys vampires for next year. So it builds, the way that the Troopers have built lore on their shows with like a full on long game, which I think is really cool. I'm excited by that. So Let's see. My kid's personal Uber driver, we do have a discount with Flow. It's not limited to finals, but we do have a discount with Flow. We will put a link in the chat and a link down below. We have our own link that will describe Flow, but we do have a great deal with Flow. It's basically pay for 3 months, get the entire year. It's actually a little bit less than pay for 3 months, get the whole year, but we do have a deal with Flow. Though we're at the point in the season where you could sign up for a month of Flow if you wanted to and get finals and just pay for the month. So we have that. We'll put that link down below. Let's see. I'm going to try to answer a few more questions from the chat, and then I've got to go because, well, we have been streaming for 4.5 hours and I still have to prep for tomorrow. And then Griff and I have stuff we need to do. Motion to have a members only Mad Libs stream. That's a fantastic idea. It's a fantastic idea. Had a school excuse Mad Lib lungs caught in VCR. School excuse Mad Lib lungs caught in VCR. That's very funny. Let's see. I am known to my husband's friends as the warden, said, asked, and answered. Governor Warden. Governor Warden. So, yes, for sure. John Doe asked, accusing Ann Taylor of unethical conduct ends attorney-client privilege. It doesn't end attorney-client privilege, but it allows for responses to the court. I think where we might have an issue with attorney-client privilege is that Bryan Kohberger said multiple times in his writing that his family was present during all of this, and his family being present negates the sanctity of attorney-client privilege. So that's what I was talking about earlier. Oh, I got a spinny wheel of death. Cindy, thank you so much for the 50 gifted memberships. Welcome to all the new members. Thank you so much. That's incredibly kind. I'm sorry I didn't see that earlier. Thank you. Craft Hex Rachel said, I used to work in university housing. Definitely sounds like a first year being upset that the dorm rooms are as small as they are and there's no cleaner that comes in. Yeah, this is your dorm and your mom's not here. And if you have a suite with a bathroom, y'all have to clean it. Right. Let's see. There are a couple more questions that we're going to get to. A lot of you are asking about takesies v. backsies. Someone asked if DCI comes to Arizona. I think there is a show in Arizona. I think there was a weather issue this year. I realize that Arizona's weather issues for DCI can be dicey because of heat, where in other places it's swirly whirlies, rain and lightning and thunder and the thunder, lightning and the thunder. So with all of that, let's see. My questions froze a little bit. So if I missed something, I apologize. Kim, we'll get to this real quick before we wrap up. Emily, on the David case, does the prosecution need to give the defense transcripts from the investigative grand jury? The defense probably already has those because the witnesses, or at least one or two of the witnesses, came up at prelim. So yes, they would have the transcripts of the witnesses that testified at the grand jury. Those would not be able to be made public, but the defense would have them because those are prior witness statements, and prior witness statements need to be turned over. So yes, and we talked about the David case on the podcast. I will update on the David case on next week's podcast. The prelim was held to answer. No one is shocked. There will be a next court date to set it for trial. It will get set for trial. It'll be a while before it goes to trial. That's where we're at on that. So no shock to anyone about anything. Ali said, question, what dyslexic accommodations would you suggest for a newly diagnosed adult student? I would, want to know the way that you learn best. So accommodations can include testing with dyslexic font, more time, being able to test take privately, being able to test take on a device that has assisted like speech to text so that you can either speak your answers in or that your test can speak to you. It really depends on the way things are easiest for you. And I would work with your school on figuring out what's available, having text or books or even lectures available auditorily. If lectures don't allow you to record the lecture with like a note taker, asking what accommodations can be made to that so that you can focus your note taking differently. Or if things are written in class, being able to get a copy of that so you can put it into a dyslexic font on your system, things like that. But there are a lot of adaptive technologies that you can ask for and work with them once you know the way that your brain works the best. And so one of the accommodations that worked really well for me and also works for one of my kiddos and not the other is being able to test take privately so you can read the question to yourself so that you can parse it more easily. Also being able to change the screen on test taking by computer, or sometimes it might be, hey, I need to test take on paper because my brain cannot process computer, but being able to change the screen to whether it's black background, grayscale, sepia, whatever works best for you. A lot of standardized tests can be changed either in the test or on the device so you can read it more carefully. And one of the things with extended time too is that you can actually slow yourself down and read something more than once or read it out loud to yourself, or have assistive technology read the question to you if you process it well. Not everyone who's dyslexic processes the same way. I know that with friends that don't process auditorially well, that having it read to you is not going to help because your brain doesn't process it well that way. So as you figure out the way you process, work with them. Remember, they're there to work with you. And extended time when you need it, because you have to double check that your reading is correct because the words are being sassy, is just needed. Also, I could go forever about the fact that I think that being able to just modify the screen that you're reading a test on should be available to everyone. I think lots of people process information differently, and just everyone should have that available to them. And that would be easier. There's fights going on with this in law school about everybody asking for accommodations. And when it comes to law, I think one of the things is lawyers are generally able to adapt their work to them anyway. So if students need bigger font or smaller font or a quiet testing environment or like not a white background, then just let them learn the best. Like, why can't we just do that? Though I think it's University of Chicago that's going like no technology at all, which I also think is going to end up in some ADA lawsuits because there are assistive technologies that are technologies. So going no technology, I think, puts students who rely on assistive and adaptive technology at a disadvantage. But we could talk about that forever. Instead of being like, well, you can use accommodations and you can't. I'm like, why can't we just accommodate how everybody learns? Brains work differently. Some people learn visually. Some people learn by listening. Some people need to write it. Some people need to read it. Some people need to listen to something while they're moving, because if they're just sitting still, they're not going to be able to embody it. Just why not? Everybody learns differently. Anyway, that's my soliloquy about everyone learns differently. And we're humans. We're like, one of the core features of being a human is that we're able to adapt our environments to us a little bit better. I think we should just start with the kids. Let them adapt their environment to them. That's where I'm at. So with that, my advice is, if you know how you learn best, ask for the help and know that those that are there to help you in your whichever department at your school handles accommodations, they're there to help you. And they probably have things in mind that we might not have discussed and that we might not know exists, and they know. So you can just ask them. It's fantastic. I learned something new. Yvonne said that's called universal design, and many schools and programs are moving towards that. I love that. It just makes so much sense because everybody's brains process differently. And I think we're getting closer to a time, honestly, when we are able to give, especially kids that are going into school, because it's easier to grab them there, as we're able to look at kids as they're going into school and start to ask them, how is this easier for you? Is it easier for you to tell me about it? Is it easier for you to make a storyboard about it? Is it easier for you to write about it? Is it easier for you to read about it? How is it easier for you to learn? And then we're able to look at the fact that it's not neurotypical and neurodivergent. I use operating systems as my analysis or my analogy. And if you haven't heard this analogy, then this might be new, but I use operating systems as my analogy. Like if you are a Mac, it doesn't matter how many Windows prompts you do. You're putting Windows prompts into a Mac. It's not going to work. If you are a Unix and you are putting in Mac queries, it's not going to work. You are using the wrong input on the wrong operating system. And I really think that humans are just on different types of operating systems. And I don't think it's just neurotypical and neurodivergent. I think it's really some are more common. Sure, a lot of people probably have a Windows machine or a Mac, different operating systems. Some people have a Linux machine. Some people have a Unix machine. Some people have a Raspberry Pi. Some people are like, fuck all of that. I have an iOS device. I don't need a Mac OS. Right. And people have all different operating systems. And so if you just figure out what operating system you're in, then you can figure out how to navigate that operating system. But if you're trying to put Windows commands into a Raspberry Pi, it's really just not going to work. And that's not anybody's fault. It's just you're putting in the wrong instructions. You can use furniture for the same thing, but if you're trying to build a piece of IKEA furniture with instructions from, not IKEA, it's probably going to be more frustrating. Then you're going to be like, why can't I figure it out? Fuck. Well, you don't have the right instructions. It's not your fault. And for a lot of us, when we grew up not understanding that just brains are all different, we were given a set of instructions and told that this is the way you should do it. And then you're like, why doesn't it work that way? Well, because you were not given the right instructions. And again, that's not your fault. But we have to figure out how to write our own instructions. So that's the analogy I like, is really trying to figure out which way you operate the best, and then giving people the ability to then use that information meaningfully to navigate. I think everybody would just be less overwhelmed. And we want people to be able to learn and engage with each other and engage with ideas. And if everybody feels overwhelmed all the time, we can't actively engage with one another and continue to learn and do better. And we have bigger struggles ahead than not letting students use an exam that doesn't have a white background. Like, we have way bigger problems. Let's let people read the things that would be helpful. So, and for those of you that have I have a difficulty with white backgrounds. You know what I mean? Where your brain only sees the void. It doesn't see the letters being letters. It just sees the void of the negative space because the white backgrounds are so overclocked. It's hard. And then when I go to look at handwriting that is not standardized, it's even harder. So today I was just like, whew. But we got through it. We were able to read everything, and there we are. So, law nerds, it is good to see you. Interesting detour in Idaho today. Who knew this case was still spicy? Mods, thank you. People are spicy about this case. The question in this case is simply, did Bryan Kohberger know what he was agreeing to in this plea? Did his lawyers tell him to lie? Did his lawyers lie to him? And was there ineffective assistance of counsel there? That's the question. We're just narrowing it down to that. And I'm sure that there is going to be much of I didn't realize there was still so much surrounding this case because, again, we don't do the sideshows. So with that, law nerds, I will keep an eye on this. We will see what happens. Because, of course, we will see what happens. But tomorrow we will be going to court elsewhere, I suspect. Who knows what's going to happen? I didn't know we'd be in Idaho today. And then yesterday I was like, oh. Interesting. So I guess we'll see. You're the best. Thank you for being here. Thank you for being a law nerd. Thank you, mods. Thank you, Team Baker. It's good to see everybody. And I will see you soon. Let's roll the outro. Don't forget to get the Law Nerd app, lawnerdapp.com. We will put links down below that I talked about in the chat. We will put documents that we talked about today in the Law Nerd Lounge. And with that, I'll see you tomorrow. All right. Oh, do the YouTube things. Yeah, those help. Do the YouTube things. Bye, Law Nerds. Wait, where's my outro? There it is. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.